And hopefully everything we talked about objections on Saturday comes back to me. That's has not been my focus for the last 24 hours.
I'm sure it will. You'll be fine. And we can always talk about it. It's fine.
Copy. There's YouTube. Send in the link to Anna. To Anna Kippenbrock. All right. YouTube link. Link. You're live. Boom. You'd think that Outlook would be smart enough to understand that YouTube is not a spelling correction that needs to be made
You think?
in its existence. What? The world will surprise you sometimes. All right. I'm going to start to admit.
All
All
right.
right. We are live on YouTube, the three of us, so you know, and I'm about to start admitting parties. Here we go.
Like a talking head. Now
I
I'm a
saw
talking portal.
I saw a really great Talking Heads cover band at the rail yard a couple weeks ago. They were incredible.
Cool.
Yeah, they rocked. And they had all the dance moves. They were incredible. All right, just so everybody can test their audio a little bit. Can everybody, hopefully you can hear me. If not, you could you could wave your hand in distress or something of that sort.
Good morning, Mr. Hearing Examiner. I can hear you.
Great. Good morning, Miss Oasis.
Good
Miss
morning, I can
Olson.
hear you as well.
Hammer, can you hear me?
Great,
I'm
I can-
hearing an echo.
Echo.
Hang on, not from you, Miss Stevens. I think maybe it was in Miss Olson's room.
Oh, okay. Thank you.
Is there an echo?
Here, let's go one at let's see. Miss Olson, why don't you give us a sentence? Let's see what happens there first.
Good morning, everybody.
Okay,
Sounds
that sounded good to me. Now, Miss Stevens, how about you say hello to us?
Good morning, everyone.
Okay, that sounds good too. Mr. Herman, how are you this morning?
I'm doing well and wondering if Miss Gonzalez can pick up. I've got some background noise in my office, so please let me know if that's going to be a problem.
Okay.
Miss Amer?
Hello, everybody. How is everyone this morning?
Doing well. Doing well.
Okay, I guess I'm hearing things because I'm not hearing it.
I think it was
Anywhere.
because a few of us all chimed in at the same time with the same intentions, so. All right, we've got a few more minutes. We'll see if there's any more activity and is that Mr. Novella there as EP witness? Can we hear if we can hear you as well?
Yes, testing.
Great, we can hear you as well.
Ms. Stevens, your hand is up. Do you have a question?
Yes, thank you.
Yeah.
I wanted to ask two questions first. First, I think to me, Mr. Getko's voice seems a little blurred, and I think I can manage it. I just wanted to make sure that Ms. Gonzalez isn't having the same problem.
Here, let me let's. Does that sound better?
It does.
Yeah.
All right, great.
I'm sorry, she's the one who matters. Also, I think during the pre-hearing conference, you indicated you wanted people to do the little hands up for objections and things like that. Is that
Um,
the
no,
case?
the little hands up will be, for items when we're discussing and
Okay.
like leading into any things. I think for an actual objection, and we'll cover this when we get on the record of, that's easier to accomplish by speaking, objection. And so, yeah.
Thank you. I just didn't want to get off to the wrong, start off on the wrong foot.
That's exactly why we're here a few minutes early. That's great. Let me make sure my phones are not going to disturb me inappropriately. And Miss Gonzalez, is the real time active right now?
Well, I'm not writing, so let's
Okay.
do a test.
Okay, here's a test of our real time.
Yes.
Okay, can you see that? Okay, so when I'm not on the record, you're not gonna
Hmm.
so now
Mr.
it's
Cope,
gone.
did you see that?
Yeah,
Did you
I
see
just
that?
got rid of that. Say again?
Oh, I was asking Miss Lecoq if she saw that. I didn't see
Yes.
it.
Oh, okay. Well, I just took it off because that's not part of the record.
Okay,
I
all
want,
right,
so when you talk, I will write when you say on the record. And
All
then you
right.
shouldn't be much of a delay.
all right. I'm gonna relaunch because of some other stuff I had, and then I'll get started with everybody. So everybody, thank you. It's gonna take me 1 minute.
Okay.
There it is. Relaunch that. There we go. Okay. Good morning, everybody. Okay. Good morning. Before we go on the record, I'd just like to address a couple of housekeeping matters. The first one is just the normal procedure that we'll take a break in the morning. We're planning on a full lunch break, and we'll take at least one break in the afternoon. We'll try to go along with how that flow goes with the flow of the case, but most importantly, Ms. Gonzalez, if you have any need to take a break at any point, of course, don't hesitate. We know your work is strenuous, and we want to make sure we take care of you. So the next piece would be that counsel and active witnesses are expected to have their cameras on, and that would be other counsel attending as well. If there needs to be an exception to that, please make a request with the hearing examiners, which brings to mind that I want to introduce Miss Erin Lecoq. We are co-hearing examiners on this matter. The witnesses that are not currently testifying, they should be watching on YouTube, and then when it comes time to testify, we'll admit them to the Zoom. If anybody's in the waiting room, of course, interrupt us, and if it starts to become a problem, and let us know. As far as being able to raise a hand in Zoom, we've had some instances recently where, because of the way it operates in Zoom, we were getting some emojis launched. Is there anybody, does everybody here and now understand how to raise their hand through Zoom? Okay. Mr. Herman, you raised your hand. Do you have a question about raising your hand?
Well, I did prove I know how to do it. And I had another housekeeping matter. I was just going to request occasional absences. I do have a conflict today at 10 a.m. So.
Okay, with a full understanding that we won't, whatever you miss will just be missed, right?
Yes.
Okay, thank you for that. And then your question was timely, Mr. Herman. My next bullet point was the question of whether there's any additional items or questions that we need to discuss before we go on the record this morning.
Yes, oops, pardon, this is Anastasia Stevens, who just dropped her camera trying to get it to show her face instead of her name. But my question, I'll work on that. My question is, over the weekend, I sent 2 emails requesting modified exhibits. One was the actual amended application, one case when I had posted the original application, and the other was a version that had the correct pagination that had gone missing in the transition from amongst documents on in PDF. So I guess I'm asking at this point, first of all, whether you would grant that request to use the better exhibits, and secondly, how we actually implement that.
Yeah, thank you for the question. Ms. Lecoq and I discussed, and I think we're going to discuss that when we're on the record, and so that parties can provide input with respect to that. And so, yeah, we saw those emails. Thank you for that. And that'll be a discussion that we have when we go on the record. So thank you. Any additional questions or input? Okay, hearing none, then Ms. Gonzalez, let's go on the record. Okay, good morning, everyone. The time is 9:06 a.m. on July 27th, 2026. We're now on the record. This matter before the New Mexico Public Regulation Commission will please come to order. My name is Kevin Gedko, and I'm here with my co-hearing examiner, Aaron Lecoq. We are the hearing examiners who will be presiding over this hearing today and possibly tomorrow, and ultimately providing the commission with a recommended decision. This is the time and place set for the evidentiary hearing in the matter of El Paso Electric Company's application for approval of its Renewable Energy Act plan for 2027 and 10th revised rate number 38 RPS cost rider. This case has been docketed as docket number 26-0000093. Notice was given by EPE in this matter, as confirmed by the company's filing of the declaration of Linda Pleasant confirming publication and web posting, filed in this docket on June 1st, 2026. This hearing today is being transcribed by our court reporter, Melissa Gonzalez. Ms. Gonzalez will also be managing the transcript of this proceeding. If the parties have any questions as to that, I would direct them to Ms. Gonzalez and her team for any answers. This hearing is being live streamed for the public on YouTube. Any witnesses should follow the hearing on YouTube until it is time for their testimony, at which point we will admit them to the Zoom.
Can you give me one moment?
Yes, Ms. Gonzalez.
I'm not. I will have to deal with that on a break. I've lost, the real time is going, I believe, but I lost the ability to see it. So I'll have to fix that on a break. Sorry about that. Thank you for waiting, guys.
Okay, thank you, Ms. Gonzalez. I'm gonna see, yep, we can see the real time is functioning on our end. So thank you for that. So the first thing we would like to do is start with entries of appearance, with each party stating its appearance for the record. And I'll start with the applicant, El Paso Electric Company, which we will commonly abbreviate today, I'm sure, to EPE.
Good morning, hearing examiner Getko and hearing examiner Lecoq. Carrie Olson from Spencer Fain on behalf of El Paso Electric Company. And here with me in the room throughout the day will be attorney Nancy Burns, Deputy General Counsel for El Paso Electric Company.
Thank you, Ms. Olson. Next, we'll turn to Utility Division staff of the Public Regulation Commission, which we will commonly refer to as staff, I'm sure, today.
Good morning.
Renee Moise, appearing on behalf of New Mexico Public Regulation Commission, Utility Division staff. Appearing with me today is my co-counsel, Judy Amer.
Yes, good morning.
Thank you. Next, we'll turn to City of Las Cruces, commonly
Good morning,
known
this is
as...
Anastasia Stevens on behalf of the City of Las Cruces.
Okay, and thank you, Ms. Stevens, and I will note that City of Las Cruces is often referred to as CLC or the city. Next, I'll turn to Doña Ana County, which we commonly refer to as the county.
Thank you, Mr. Examiner. Keith Herman on behalf of Doña Ana County.
Okay. Thank you. That's the extent of our parties today. I'll note for the record that there were no individuals or entities who signed up for public comment this morning. I'll also note that CLC and the county did not file testimony and are not presenting witnesses today. But as intervening parties, they have the right to cross-examine the other witnesses. As we discussed off the record, we'll take a morning break, a longer lunch break, and at least one break this afternoon. And then I briefly want to cover how we'll handle objections that come up today. If council has an objection, the council shall state objection. We'll pause. The hearing examiners will ask what the objection is. They'll receive the response. The hearing examiners will then ask the witnesses' counsel to respond to the objection. And then we'll proceed from there with all input from counsel being in response to a prompt from one of the hearing examiners. The goal here is to prevent counsel from speaking over one another. If we were to let that happen, we simply would lose control. And so please do your absolute best to maintain that procedure today. And if we stray from that, we will definitely interrupt and reset ourselves. As indicated at the pre-hearing earlier this week, the order of presentation of witnesses and of cross-examination will proceed in the order of EPE, then staff, then CLC, and then Doña Ana County. Each party has been allotted 4.5 hours total for cross-examination of other parties' witnesses. Hearing examiner Lecoq and I will be keeping track of that time. One item that I think merits consideration right here at the start before we turn to the introduction of the first witness is an item that has been raised by Ms. Stevens for the city of Las Cruces. This weekend, 2 exhibits were provided. One of them aims to correct what appears to be typographical issues that occurred when the document was uploaded. The second one appears to be a request to admit an amended application from a prior case as an exhibit, well, not admit, but to present in the Dropbox a prior application that was amended as opposed to the initial application. Is that a fair representation of what your request is, Ms. Stevens?
Absolutely, Mr. Getko.
Thank you. Ms. Lecoq and I discussed this morning, and we thought the first step we would take is to see if there's input on that from any party at this moment. Yes, Ms. Olson.
Hearing examiners, as I indicated at the pre-hearing, I have objections to a number of the city's exhibits, but those objections don't extend to, or let me think of how to phrase this. To the extent Ms. Stevens has uploaded new or different exhibits, I don't have a concern necessarily with that. It's more to the exhibit itself that I intend to be objected to. And if the hearing examiners would like to provide guidance on whether they prefer I preview those objections now or just make objections on a case-by-case basis as the documents come up, I would appreciate it.
Okay, thank you, Ms. Olson. First, with respect to the second piece of what you just communicated, Ms. Olson. With respect to those objections, our plan is that those objections would be handled on a case-by-case basis as those exhibits are introduced during cross-examination, given the situation where there's not a witness from the city. There's an understanding that those exhibits are going to be used during cross-examination, and we think we should address those at that time. And then just to clarify what I understood with regards to the first piece of the answer is that there isn't an objection to adding the two proposed exhibits to Dropbox that Ms. Stevens emailed to all the parties this weekend. I'm gonna give everybody 1 or 2 more seconds to see if they have input on that. Hearing none, then we'll go forward with that. The process, Ms. Stevens, and I know this could be a little bit difficult right now, and I may need to double check whether that Dropbox is active, is we will want to label those as corrected exhibits. According to the naming conventions that were included in the order on Zoom protocol and exhibit exchange, and upload those to Dropbox. I feel that we could accomplish that over a break, given that they've been emailed to everybody. As far as the upload goes, I think we can do that over the break. They've been emailed to everybody, but can you state for the record right now exactly the changes that you are requesting to be made so that it's on the record?
Okay,
And which exhibit number it is as well, please, Ms. Stevens.
let's see. Let me get the right thing in front of me so I don't confusing it more than possible. Okay, so what we have here, I labeled them replacement exhibit when I sent them to you, and then realized that that was the wrong convention when I looked at the companies and saw they used the corrected afterwards. But they are replacement CLC exhibit number 13 in docket number 22-00093-UT, and that's the revised application. I had originally uploaded the original application going to the very bottom of the docket on PRC E360, and the case was proceeded on this revised application. So it was my mistake. The other one is replacement exhibit number 1, TLC exhibit number 1, and that's the company's EPE's application in docket number 25-00038-UT, which is last year's El Paso Electric Renewable Energy Plan application. In that instance, I believe, after looking at it and comparing, because I believe what I did was when I put the header on per the instructions to label the case number, I deleted some pre-existing headers and footers. Apparently not all, because there are some page numbers that remained, but a lot of them. And importantly, because the primary reason for putting that, for using that in the record, is because that contains the original Santa Teresa project purchase power agreement, or PPA, and this original Santa Teresa energy storage agreement, or ESA, which are, of course, in play again in this docket. So it's a matter of convenience in that case. Otherwise, we go looking through hundreds of pages and using the PDF numbers.
Understood. Thank you.
No content change at all.
Okay, thank you. And Ms. Olson, do your witnesses have access to those 2 documents at this time? So that
The
when we
corrected-
proceed to cross-examination, they would have ready access to the 2 new documents that we have just determined would be allowed to be considered as exhibits for today's hearing?
Mr. Hearing Examiner, we provided all of the exhibits that were uploaded by the city to the witnesses as far as the corrected exhibits that were provided yesterday. I think we may just have to verify with the witnesses, or Ms. Stevens may have to screen share. I'm not sure.
If I may, it looks like our case management team did upload them. I see a replacement of CLC exhibit number 1 and replacement file for CLC exhibit number 13.
Thank you, Mr. Novella, and excellent. And on that note, I do want to just say thank you to everybody for the solid work in preparing exhibits, and we're working towards that in the Hearing Examiners Division, and I think we saw some success this week, so thank you. Okay. With that, I believe it's time we can turn to our first witness. And so, Ms. Gonzalez, would you please swear in our first witness, Mr. George Novella?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And Ms. Olson?
Good morning, Mr. Novella. Can you hear me okay?
Yeah, very well. Good morning.
Mr. Novella, can you please state and spell your name for the record?
Yes, George Novella, N-O-V as in Victor, E-L-A.
And Mr. Novella, what is your position at El Paso Electric Company?
Senior Director of Regulatory Policy and Rates.
And Mr. Novella, do you have in front of you what's previously been marked as EPE Exhibit number 1?
Yes,
Do you recognize that exhibit as the pre-filed direct testimony that you submitted in this proceeding?
that's right.
Was that direct testimony prepared by you or under your direct supervision?
It was.
And do you have any corrections to that direct testimony?
I don't.
Do you swear or affirm the information in that direct testimony is true and accurate to the best of your knowledge or belief?
I do.
And if you were asked the same questions today under oath, would your responses be the same?
I would.
Hearing Examiners, El Paso Electric submits El Paso Electric Exhibit number 1 and exhibits to the record.
Parties, are there any objections to the admission of EPE Exhibit number 1? Hearing none, EP Exhibit number 1 is admitted to the record. Ms. Olson.
And Mr. Novella, do you also have in front of you El Paso Electric Exhibit number 2?
I do.
And do you recognize this as the pre-filed rebuttal testimony you submitted in this case?
That's right.
Was that pre-filed rebuttal testimony drafted by you or under your direct supervision?
Yes,
And is the information contained therein true and accurate to the best of your knowledge and belief?
it is.
Do you have any corrections to that testimony?
I don't.
If you were asked the same questions today under oath, would your responses be the same?
They would.
Hearing Examiners, El Paso Electric submits EPE Exhibit number 2, the rebuttal testimony of George Novella.
Thank you. Parties, are there any objections to the admission of EPE Exhibit number 2? Hearing none, it is admitted.
Hearing Examiners, that's the only exhibits we have for this witness, so submit him for cross-examination and examination by the Hearing Examiners.
Thank you. Staff, do you have any cross-examination for this witness?
Mr. Hearing Examiner, staff has no questions for Mr. Novella. Thank you.
Okay, thank you. City of Las Cruces. Do you have any cross-examination for this witness?
Mr. Hearing Examiner, I certainly do. Good morning, Mr. Novella. It's good to see you.
Good morning. Good to see you as well.
You're a really busy person these days. I see you're in charge of rates, all rates, huh? Okay, so I'm going to ask you start with some general questions. In this case, you're testifying as EPE's sort of company representative, is that right?
Yes,
And you acknowledge that EPE's projected load growth in New Mexico is based in considerable part on the potential for adding at least one so-called large load customer. Is that right?
Objection.
Yes, Ms. Olson, your objection?
That sounds like testimony of counsel.
Let me see the real time real quick. Ms. Stevens, can you restate your question as a clearer question, please? Objection granted.
I'm not exactly sure. Okay, so is EPE's projected load growth in this case for purposes of the 2027 RPS compliance based in considerable part on the company's potential for adding at least one large load customer?
in part.
That's right. And is that what large load customer commonly being called as Project Jupiter in southern New Mexico?
No, I believe we call it a borderplex in this filing.
Borderplex. And I don't want to pull up we spend time pulling up the exhibits, but in Mr. Mr. Villalobos's exhibits, he has a loads and resources table that refers to it as Project Nucleus. Is that something you're familiar with too? Because I wasn't.
I believe so. I believe they might be used interchangeably in different parts of the filing.
So Nucleus, Jupiter, and Borderplex are being used interchangeably. Is that
No, that's not what I said. And earlier
Oh.
when you asked me about Jupiter, I said no to that. So I was talking about nucleus and borderplex.
Okay. And okay. And that is or is not what's being called locally Project Jupiter.
No, I believe they're separate projects.
Okay. And what the company is referring to in this case, as shown by Mr. Villalobos's loads and
I'm sorry,
resources table.
I need you to speak up a little bit, Ms.
Okay,
Stevens.
what
And
the
I'm not
company
able to-
is referring to in this case as the new large load would be that Borderplex or Project Nucleus project. Is that right?
Can you restate?
Objection.
I'm going to pause for a second, given Mr. Novella's question. Can we restate the question, please, clearly? Ms. Stevens?
I'm sorry.
I believe we may have had a little bit of issue here with a pause in a video. There was also some communication issue with a couple people speaking just coincidentally. Could you please restate your question, Ms. Stevens?
Okay. I mean, this may not be a restatement, just trying to get to the same point. So is EPA talking about when it refers to a large load customer in New Mexico, is it talking about this Borderplex, which is also referred to as Project Nucleus?
Yes.
Objection.
The question was answered prior to the objection, therefore the answer stands.
Okay. Mr. Novella, would you please refer to CLC exhibit number 32. And I'm not sure that we need to bring this up if he has access to it, rather than spend the time putting it on screen.
I have access to it.
Okay. And
Mr.
is
Hearing
that,
Examiner, object to this exhibit.
Please state your objection, Ms. Olson.
Mr. Hearing Examiner, I haven't done anything with him other than
Miss-
ask him to pull it up, so I don't know
Ms.
what
Stevens,
she's
Ms.
objecting
Stevens,
to.
Ms. Stevens, let's first let Ms. Olson state her objection as we discussed at the start of the hearing, and
Okay.
then we'll proceed to see your response. Thank you. Ms. Olson?
Mr. Hearing Examiner, I object to any questioning or reference to this exhibit as hearsay and outside the scope of the hearing.
Ms. Stevens, your response?
Well, first of all, I'm not sure how it's hearsay because it is a discovery response that Mr. Novella himself sponsored in the general rate case 25-00082 UT. And secondly, as our my brief conversation with Mr. Novella indicates, the loads and resources table for which EPE, it was upon which EPE is in part relying in this case, ties the load growth, the need for additional capacity, explicitly to that potential new large load.
May I respond?
Yes, Ms. Olson.
By definition, hearsay is a statement that's made outside of this hearing, so it certainly is hearsay. To the extent Ms. Stevens is indicating it's relevant to this case, it's not. It's ongoing discovery in a pending litigation. And EPE has presented the testimony and evidence in this case that it's relying on for proposals in this case. And I just want to be extra cautious about introduction of any evidence in the ongoing rate case, because those are all pending issues that are currently being litigated before this tribunal. And I think it would be a grave mistake to open this case up to examination and questioning about ongoing litigation.
I'm going to allow one more response and then I'm going to give it some thought. Ms. Stevens, you have your hand up. I'm assuming you have
Yeah, I
one
just
more
wanted
response.
to ask to be allowed to respond to Ms. Olson.
Yes.
Okay, this is a document. It's not an out-of-court statement. It's a document signed by the company. Mr. Novella has just testified he is the company representative. He's the role of the company representative. And he's obviously familiar with it because he sponsored it in the other case. So I'm not sure where the hearsay objection is, and I have yet to move to admit it into evidence.
Okay. Thank you, everybody, for following the protocol and not speaking over one another first. I'm going to look at one thing on the transcript here really quickly. Okay. It has not been asked to be admitted yet. And hearing the objection with respect to it being admitted with respect to hearsay, perhaps that has grounds, but we will allow it for the purposes of impeachment of the witness at this time. So we-
Mr. Hearing Examiner, for purposes of preserving the error for appeal, I just would object to questioning on documents that have not been admitted to evidence because they're not, the hearing officer has not made any indication on whether or not those documents are reliable. So I would just make that continuing objection.
Understood. Thank you for that. And perhaps a better way for me to speak it is, for the purposes of it being admitted, the objection is sustained at this time, given where we stand, but it's allowed for impeachment. Okay, let's proceed, Ms. Stevens.
Okay, I'm not sure what I'm going to be, how often I'm going to be stopped here, but Mr. Novella, that agreement is called a precedent agreement, is that right?
I don't recall what it's called.
And was it executed in December of 2024?
Mr. Hearing Examiner, I apologize, but I have to object to this questioning.
On what grounds do you object?
I'm objecting, this is not proper cross-examination. This is well beyond the scope of Mr. Novella's direct or rebuttal testimony. I don't think that the agreement Ms. Stevens is questioning on is an evidence in this case. I don't think Mr. Novella has given any testimony.
I'm sorry,
about-
please repeat what you just said, the very last thing.
Apologies. I don't think that the evidence, I mean, the agreement Ms. Stevens is mentioning is in evidence or has been discussed in this case. And I don't think that Mr. Novella has provided any testimony in this case on a potential agreement with a large load customer.
Let me see what the response. Hold on one second. I do believe Mr. Novella testified about EPE's projected load growth. And this is what EPE's projected load growth is comprised of.
Okay,
And that's the reason, and the point of my cross-examining and possibly admitting this document into evidence is to try to clarify what EPE knows at this point in time today about the likelihood of that load coming on ever or exactly when. I mean, I'm putting all
Here's
my
what I'm
cards on
gonna
the
do.
table, Mr. Hearing Examiner.
I'm going to take a couple minutes off the record. I'm going to discuss it in detail with my co-hearing examiner, and we'll
Ms. Stevens, while we're off the record, if it's helpful, if you want to ask Mr. Novella the substantive questions without bringing in the documents, I'm sure he can answer them, but I intend to object to the documents and substantive information that's outside the record in this case.
Let me give that some thought, Miss Olson, and I do not know whether while we're off the record, we're also, you and I are on YouTube, so I think we need to be cautious, okay? Or we should ask them when we get back what's on YouTube and what isn't.
I don't mind this conversation being on YouTube. I was just trying to offer
No, I understand.
some indication into what I was thinking in order to be able to streamline your cross-examination.
Miss Olson, looking at my notes, I mean, I'd rather have it in the record. and perhaps the hearing examiners are going to want to have it in the record. I guess I can arduously go through other discovery responses to get to some of the points. I'm not sure whether all of them though. And those are the ones that have to do, again, as I mentioned to the hearing examiners, with timing and certainty of this load coming on.
If you want to avoid objections, I would just ask those questions to Mr. Novella and avoid relying on hearsay from other proceedings. I know you disagree it's hearsay, but by definition, any statement by anybody, written or verbally, out of court is hearsay.
Unless
and
it's
I
by
will
a
continue
party.
making those objections.
But that definitely falls in the exceptions of hearsay. These are statements that he's made sworn that could be against interest.
I don't see how it's against his interest, but
Well,
we can
that's a
have that fight on the
foundation
record.
issue. I'll leave it to Ms.
Hey.
Stevens to establish a foundation.
I'm
As to
sure
why
Ms.
this is
Stevens
relevant.
can do the legal analysis herself. I'm just saying that if we want to move quickly and avoid objections, I'm offering it for that purpose only.
Well, I just hope this isn't counting against my 4.5 hours. I don't know who's got the clicker.
You guys, I'm gonna jump off 1 second. I've got a
Okay, I'll give everybody a minute to come back on screen. Miss Owais, should I be waiting for Miss Amer or not?
Mr. Hearing Examiner, I think we can proceed. I'll touch base with Miss Amer just to make sure she's available.
Okay, thank you. Okay, let's go back on the record. Hearing Examiner Lecoq and I discussed, and one thing we want to differentiate here is between the objection with respect to the document possibly being hearsay and the concern that's been raised regarding documents that are part of an ongoing litigation in another matter. This being a discovery response in another matter. That creates some questions for us with respect to relevance and the ability to verify that information, in addition to other concerns that we have. So with respect to that, our decision on this matter is that questions can be asked on the topics so long as they're within the scope of this case. And objections may be raised with respect to scope, of course, as items are raised in questioning. But with respect to the ability to eventually seek admittal of this into this docket, we have reservations. And sorry, I just got interrupted with something. And so to kind of restate that, we would ask that, you know, and it's already been established that there's some knowledge here from the witness with respect to the document. But we don't want to center on that document that's part of ongoing litigation. Questioning can continue so long as it's within the scope of this case and does not aim for admitting this document that is in ongoing litigation straight into this case. And that's our ruling on that objection at this time. Ms. Stevens, you may proceed.
Yeah, I don't see the witness anymore. Is he out there?
Sometimes when people come off and come back on,
Oh, there
the
he
gallery
is.
boxes change.
Okay. Too few. I need to enlarge this. Enlarge this. Okay. May I ask how much time I lost there, Mr. Hearing Examiner?
I made a note to take 10 minutes and have that not be counted towards your time.
It's 9:51, and I think I've asked only a few questions. But that seems like it was long. I guess I better keep tabs more closely myself then. Okay, so Mr. Novella, I think before the objection arose, I was asking you, and you answered, but your lawyer objected that the contract dates to December 2024, right?
Which contract are you referring to?
The Borderplex contract it's CLC Exhibit 32.
Mr. Hearing Examiner, I'm gonna object. She's referring to an exhibit that's not in evidence. And when you go back to look at this record, if that document's not in evidence, it doesn't make any sense.
Ms. Stevens, your response, and then with my co-hearing
Okay.
examiner will rule after your response.
I guess I can rephrase the question, although I think that we all know what we're talking about here, and it may eventually be admitted into evidence. Mr. Novella, did EPE reach an agreement with Borderplex?
1 second. I'm going to
Okay.
sustain the objection
Okay.
and start your questioning again, Ms. Stevens. Thank you.
Mr. Novella, did EPE reach an agreement with Borderplex Digital, also known as Project Nucleus, in December 2024?
I'm not sure. I'm not part of the business development team or have them under the purview of my responsibility. So I'm not familiar when dates of executed agreements would have occurred.
Mr. Novella, did you sponsor a discovery response in the general rate case that contains nothing but that agreement?
I don't recall. I sponsor a lot of documents within the rate case.
Okay.
Can you point me to a file or something to look at?
Yes, would you look at CLC exhibit number 32? I think we're going around circles here.
I did open that, but it's a large document. Can you point me to where in the document? It's a lot of RFIs.
Go to the response to, okay, let's go to the response to CLC 1-1 or 1-01 in EPE's language. It would be the first one after the objections.
I'm there.
Okay. And do you see that you were the sponsor of that exhibit?
Yes, let me read the question and answer, please. Okay, I've read it and I see I'm a sponsor.
Okay. And as the sponsor, you also affirmed that response? We go towards the back of that exhibit. Let me see if I can find your affirmation.
I'm sorry, find your what?
Did you provide an affirmation regarding that particular document? I think maybe I didn't attach it. Oops, I may have not attached the affirmation. Let's move on. So, were you aware was the company aware in December 2024 that it had an agreement with this Borderplex or Project Nucleus for service to a future, what the company calls large load customer?
I understand there's an agreement as described in this response that you pointed out. When you mentioned the dates, again, I'm not familiar with the dates. I'm not a part of the project team that interfaces with these customers. They're not under my responsibility. There's a separate department called project development or business development that works with them. So I'm unfamiliar if at that point in time that was signed or not. It's not in the response here that you have me reading.
Did you look at the actual contract behind the response, which is what you've
Mr. Hearing
sponsored?
Examiner, object.
Your objection, Ms. Olson?
Mr. Novella, the question has been asked and answered. He's given his testimony. Ms. Stevens may not like it, but that's his answer.
I'm going to overrule the objection, given the impeachment process that has now gotten underway with respect to this information. I think we're just exploring the contours of it at this point. So I'm going to overrule the objection. Ms. Stevens,
Mr.
you may
Hearing Examiner, can
continue.
I just ask for clarification?
Yes.
I think Mr. Novella answered, he sponsored the presence of the agreement, but he doesn't know the contents of the agreement. He didn't draft the agreement and he's not a lawyer. So I'm not sure, we can continue asking questions about the contents of the agreement, but his testimony is he's not familiar with the contents of the agreement.
Without my having processed the full amount of the document that's being referenced here, and to which Mr. Novella commented that he did sponsor, I don't think it's clear what the basis is for that sponsoring of that answer. And I'm going to let the questioning continue for a bit and see whether there is additional information tied to that answer that was sponsored by Mr. Novella. Ms. Stevens, you may continue.
Okay, Mr. Novella, do you have any reason to doubt that that document that you sponsored, what you say you are not familiar with, which has the date of December 19th, 2024 on its front page, was executed by El Paso Electric at some time other than on or about December 19th, 2024?
I'm not familiar with the document when it was signed. Do you have the document that I could look at? So I could see?
Yes, I thought you just looked at it.
No, you pointed me to a RFI response, and I just see the response itself. Is there an attachment with that document?
Yes. How about if you go to, I'm sorry, in the PDF. Did I lose it? It is page 20 of 49 in the PDF, right after your sworn affirmation, which is on pages 18 and 19.
Okay, I'm on page 20.
Okay, let's go back to page 18 and 18.
Okay, I'm there.
So did you affirm 18 and 19 on June 5th, 2026 that the attached document, which is a response to 101, CLC 101, is true and accurate based on your knowledge and belief?
I'm sorry, what page did you want me to go to?
Looking at the affirmation on pages 18 to 19.
Okay, I'm there. Can you restate your question?
Did you affirm that the contract that follows, which is part of CLC 120, is true and accurate based on your knowledge and belief? That would be paragraph 3 of the affirmation.
I'm sorry, there was two people talking. I don't think I got the whole question. Miss Olson, I'm sorry, and Miss Stevens.
Let's let the question be stated, and then Ms. Olson, if you have an objection, please go ahead and introduce it once the question has been stated.
Okay, so I'll start over again and take Mr. Novella to page 18 of 49 of CLC exhibit number 32. And did you, on June 5th, 2026, as shown by the following page, affirm under oath or under penalty of perjury, not under oath, that your exhibit 120 is true and accurate based on your knowledge and belief?
Is there hearing examiner of an objection?
Your objection, Ms. Olson?
I think Ms. Stevens is mischaracterizing the discovery. I think the affirmation goes to the discovery response. And we've gotten pretty far afield of what the actual discovery question and discovery response that Mr. Novella was responding to. I tried to avoid going down this rabbit hole because, again, it is an ongoing litigation, but now I think we've just gotten into mass confusion.
I'm going to overrule the objection for the moment because this question is only as to whether Mr. Novella affirmed what has been read off of the document on pages 18 and 19.
Right, with
So-
the additional language that Ms. Stevens is talking about, the agreement, not the actual discovery response that was affirmed.
We went back to page 18 and 19. The question is being asked about pages 18 and 19. If we proceed further along, we'll address it at that time. For now, the objection is overruled. Mr. Novella, please answer the question.
Yes, Mr. Hearing Examiner. So the way I understood the question, counsel said that I was affirming to the contract or the agreement, and I don't believe I was. I'm affirming to the overall response that was prepared by the preparer, in this case listed as Ms. Ortwine, who works for the Business Development Unit of El Paso Electric and interfaced and let me know. And my understanding was that at this point in time, this was a correct response as the document that would be responsive to this question. Now, with regards to the actual contract, again, I'm unfamiliar with its details and its contents.
May I? That is not quite the question I asked you. The paragraph 3.
I'm
Of
sorry, I'm going to
your
pause everybody.
affirmation.
Somebody has a YouTube on. We've started to get feedback.
Not me. Really?
Okay, let's try and proceed again.
Okay. I'm going to direct you again to your declaration, Mr. Novella. And you see that paragraph 3 says that the foregoing responses, together with all exhibits sponsored therein and attached thereto, is true and accurate based on my knowledge and belief. That would be responses and exhibits. Am I right?
That's what I read there. That's right.
Okay.
I'm sorry. I'm
That's
sorry,
what I
Mr.
read.
Novella.
No problem. That's what I read there.
So you did affirm that the attachments were true and correct, true and accurate based on your knowledge and belief.
I believe that they're responsive and that the preparer who works with these customers and interfaces with them, I don't, confirm that they were accurate at the point in time that they gave them to me. This type of work is not done under the purview of my responsibility. So I'm not familiar again with every detail in these contracts or most in this case.
Okay. And Mr. Novella, I'm not asking whether you're familiar with every detail, right? I'm just asking whether you did in the course of the other case, affirm it in your role as I guess similar role to what you have here as sort of the company lead witness and spokesperson. Is that right?
Can you restate your questions?
Yeah. Did you in the general rate case in which this discovery response that you affirmed was given, were you serving in a similar role as the company spokesperson as you are in the present RPS case?
I don't consider it a spokesperson, but as a policy witness, speaking on behalf of the company, I sponsored this item in that ongoing litigated case.
And now if we can turn to the actual attachment, which would be PDF page 39, page 20, pardon me, 2049. Do you see that it is entitled Precedent Agreement?
I read that on top, yes.
And do you see that it's dated December 19th, 2024?
I see that date on the first line.
Do you, based on your affirmation on the previous page and everything you know about how the company does things, do you have any reason to question whether that some sort of an agreement, which you may not know all the details of, was in fact executed in December 2024?
It says it was the effective date. I have no reason to doubt that was the effective date. I'm not sure what date it was signed. So.
Okay, thank you. Now, I'm going to ask some questions about that agreement and you have to tell me if you don't know the answers, but when we'll follow through if you don't, because they're going to be pretty broad, general questions, okay?
Okay.
So, do you know whether the maximum load to be served under that agreement is 80 megawatts?
I'm unfamiliar with this agreement. I'm not sure if there's maximum language in the agreement.
Okay.
I'm sorry, you cut out. I'm not sure if there's maximum.
Load in the agreement.
Do you know if this thing that's called a precedent agreement is meant to be the final agreement between the company, El Paso Electric Company, and this entity, Borderplex Digital Verde LLC?
I don't know.
Do you know whether EPE is expecting to serve all or part of the possible load under this agreement in 2026?
I'm sorry. All or possible load of what?
All or a portion of the load that is at issue in this agreement with Borderplex Digital.
I don't recall the exact timing of their load ramp or load profile.
You do not recall the exact timing, but you do know that there's a load ramp involved. Is that right? From your answer?
Yes, every customer has a load ramp. They all start building their facilities, and they'll scale up to whatever they end up consuming, right? So that when I reference a load ramp, it's essentially building up to their what I would call steady state or normal operating behavior.
I'm now getting on with getting back into the present case and not just that contract. Did EPE include any energy in its load projection used used for establishing its 2025 RPS plan, Renewable Energy Act plan?
Mr. Hearing Examiner, I'm gonna object as outside the scope of this proceeding on the plan for 2027.
Response, Ms. Stevens?
I'm just trying to get a chronology here. It's probably marginally within the scope, but I'm trying to get a chronology for how EPE has built up inclusion or not built up inclusion of a tentative or prospective large load customer, because these are big numbers for RPS cost rider or RPS cost recovery, which affect all ratepayers, including the real ones, not just the potential ones.
Objection overruled. You may continue with the question.
Okay. So the question, Mr. Novella, was, did EPE include large load customers, large load, what's called a large load customer in its 2025 projections for its 2025 RPS cost rider?
I don't recall. I want to say we've included them in this year's plan and the previous year's plan, which would have been 2026. I don't recall if they were in the 2025 plan that would have been coming from the 2024 forecast. I don't recall.
Okay. And I think you just answered 3 of my questions. So maybe we're making a little progress here, okay? As far as including, you did expect to have some load in 2026, is what I think you just said, as far as your projections.
From what forecast, from what filing? I'm confused on what you're asking.
Can you tell me whether you know the date in which that load would be expected in 2026 to begin to appear under this load ramp theory?
Sorry, again, I'm confused. You've asked me about our load forecast for several years, for like the same
Okay.
years going forward. Can you be more detailed in your question?
The load forecast that the company used to establish the present RPS cost rider, which was established in case 250038, did that include some large load energy, renewable energy requirements? I think you've already testified that it did in your recollection.
Me rephrase let me give you an answer as I understand your question. Is there a large load customer in the forecast as an input into the 2027 plan? And the answer would be yes.
And I know, actually, my question was about the 2026 plan, as well as not start with the 2026 plan. Was that forecasted?
So the previous year's RPS case, I was not in that case. I believe there was a large load customer in the forecast that went into that plan. I'm not recalling the details of exactly when that large load customer started producing energy and what month.
Now, the large load customer isn't producing energy, is it? It would be consuming energy?
Consuming, that's correct.
And has a large load customer begun consuming energy now in 2026?
Not that I'm aware of. I know we're not serving a customer under our large load tariffs or serving this customer. There may be some kind of construction power that I'm unaware
okay.
of. Sometimes
Gotcha.
that I would consider that serving.
Okay, I understand that. Now, are you expecting to serve a large load customer in 2027, which is the case that we're now talking about here, this case?
Yes.
And when in time are you expecting that large load customer to begin taking service?
I'm not exactly sure what the most recent or current month is where we're anticipated to start serving them. My anticipation or my belief is it'll be fairly soon.
In 2026 or in 2027?
I'm not exactly sure what month is the latest that they've given the company. With these large load customers, sometimes their plans may change, move forward or backward a bit. EP witness, Mr. Villalobos, may be helpful, give you an exact month that maybe they're anticipating. Now, with regards to when we'll be serving them, when we forecast originally, it's several months before, and it's a static point in time, right? Things change and plans develop and ramps, as we've talked about, change. So you could get the latest date from him. He'd probably give you something better.
Think so? Okay. And I do, Mr. Novella, I think of you as the load forecast expert of all time, because I know you're terrific at it, and I don't know whether you've left it all behind.
Sorry, I'm sorry. I think of you as a large load
As
forecast
the large
expert.
load forecast witness of all time, Mr. Novella is superb at load forecasting. So I just figured maybe you're just into this stuff still.
I'm gonna step in here just very
Kind of.
briefly and suggest
Okay,
that
let's move on then.
excuse me, Ms. Stevens. Ms. Stevens. I'm gonna step in for a moment here and suggest that commentary that surrounds the question isn't going to help with time or with clarity of the
Okay.
answers from the witness.
Alrighty.
Thank you.
I do appreciate Mr. Novella's skills. He even teaches this stuff. So now I'm going to take you to your direct testimony at question 16 on page 11. And the question we've all been waiting, I think some of us have been waiting for, has the Santa Teresa project reached commercial operation yet?
That's a good question. And that one may be also, or it is better for Mr. Villalobos. My understanding is that the solar's been operating for some time, full operational capability. And I believe they were waiting for a declaration on the battery storage to get the COD on that. he may have something fresher for you with regards to the current status.
Is it your understanding that the battery storage is to some extent being utilized and it's just this formality of the commercial operation certificate?
I'm not sure. That'd be a better question.
Okay. Poor Mr. Villalobos. And you testified that the Carne project reached COD, a commercial operation date, on April 21st, 2026. Is that correct?
That's right.
Okay. When did each of them begin when did Carne begin generating test energy?
I'm not sure.
Do you know whether it was in 2025 or in 2026?
I don't. That'd be a better question for Mr. Villalobos.
And how about Santa Teresa? Do you know when that began generating test energy?
I don't.
Okay. But your testimony is that they are both, at least within, at the time you filed your testimony in May, test energy had been produced by both facilities. Is that right?
Yes, by the time May occurred, COD had occurred for Carne, and I believe there was some solar production coming out of Santa Teresa.
Has EPE been applying that test energy to its 2026 RPS compliance?
I'm not sure. That'd be another question for Mr. Villalobos. He sponsors and testifies with regards to the RECs and what RECs have been used or haven't been used.
Mr. Novella, how come, why did you sponsor the annual report for 2025 if Mr. Villalobos is the one who has the information about the RECs? I'm a little concerned. For future questions, I just would like if you could give me a little roadmap.
Yeah, my understanding is just a really broad document with a lot of information, and there's parts of that document that don't fall under the purview of Mr. Villalobos' testimony, such as there's a section on demand response and time varying rate pilot.
I'm sorry, there's a section on what response?
Demand response and time varying rates programs and other items. So it's a fairly broad document, and that's why I sponsor it.
And if I end up asking Mr. Villalobos about it, is he going to deny knowledge of it? I mean, what is the role between the two of you and others at the company in preparing it?
Sure. So with regards to your question, the original question on RECs, he would be the person to ask. His testimony kind of clearly highlights that. It gives you the math around the RECs, what we're retiring for compliance, and our plan. So I think he's clearly the lead on that.
Okay, let's go on to something else. I'm probably not doing a good enough job of keeping my list for him, but I will try when we have a break to get organized. And I have another question about the operation of the existing facilities, Santa Teresa and Carne. Do you recall that the city asked the company in discovery a request for admissions about whether the Santa Teresa BESS or battery energy storage system may be charged from the grid or only from the adjacent solar facility?
I don't recall that question.
Would you turn to look at exhibit CLC 33? And I would steer you to, I should have put the PDF page here, the response to 119, which is at PDF page 35 of 340.
I'm there.
Okay, this is one that Mr. Villalobos sponsored, but I'm just going to ask you whether you know from your own knowledge whether the Santa Teresa BESS can be charged from the grid or just from the facility, just from the Santa Teresa energy facility.
I
PV
don't
facility.
know. I'm looking for the responsive portion to 119 on this subject. Can you point me to that?
36 pages 35, the questions on 35, the answers on 36, 119.
Do you know
A,
the
B,
AB? Okay.
I'm sorry, I didn't even hear the last thing. 119.
A and B.
Thank you.
And can all parties do their best efforts to speak clearly and a little bit more loudly, please?
Okay, I'm seeing the response. Yeah, I'm unfamiliar with that. And as you said, it's sponsored by EP Witness Villalobos, and I'm not on this
All
document.
right.
Yeah,
Or
better
Mr.
question for.
Villalobos. Um, I will tag these as being for Mr. Villalobos and move on quietly. Give me a little bit of time here.
I can't tell you. I just know it's an integrated facility with solar and battery. So they're
I'm
both.
sorry, please repeat your answer.
It's a integrated facility with solar and battery, 150 megawatts solar, 150 megawatts battery, and obviously here we're seeking just the remaining 100 megawatts of battery. Now, with regards to that charging, yes, that'd be a better question for Mr. Villalobos.
Okay. Um,
I'm
would you move on to the response to 120 on page 38 of 340?
Okay, I'm there.
Okay, this one, if you look at the bottom of the page, they were sponsored by both yourself and Mr. Villalobos.
I see I was a co-sponsor.
Okay. Okay. So there's a statement there. If you flip back, the question on 120C was what regarding the Carne Best state whether all the energy used to charge the battery storage facility has come from the Carne solar facility. And then if you flip to the answer, it says no, the Carne Best charged from the grid only on one day. And then it refers up to attachment 2. And if you skim down, you can see that attachment 2 consists of 190 pages. Are you familiar with attachment 2?
No.
Are you familiar with the fact that the Carne battery energy storage system charged from the grid rather than from the Carne solar facility on one day?
Mr. Hearing Examiner objects.
Please state your objection, Ms. Olson.
It sounds like Ms. Stevens is reading alleged EPE responses into the record as kind of a factual assertion and then testing Mr. Novella's knowledge about the alleged factual assertion, but the underlying facts are not in the record. And so it is appearing to just be testimony of counsel.
Response, Ms. Stevens?
I'm not sure. Maybe I'm being here. Maybe I'm being a little sloppy here. I mean, I started off by asking him, I'm asking the witness, I'm sorry, I was very rude, Mr. Novella, I shouldn't have referred you as him, about whether he knew whether it had been charged from the grid or not. And I may have overstepped a little bit. I don't necessarily want to take the time to read the
Given-
record back to figure that out.
given your response, Ms. Stevens, I'm gonna sustain the objection and encourage you to restate your question clearly as a question
Okay.
that Mr. Novello can answer.
Mr. Novella, referring to the company's response, sponsored in part by yourself, to CLC 120, especially 120C, did the Carne BESS or battery energy storage system charge from the grid at least once?
Looking at the response, that'd be a better question for Mr. Villalobos. Looks like the preparer was a person in his department. That's what I read in the response. When you read it, it says, no, the Carne BESS charged from the grid only on one day. So I read that in the response, but he can give you more detail with regards to your question.
Okay, when you sponsor a discovery, this general question, when you sponsor a discovery response, Mr. Novella, why is it that you or a different witness is chosen to be the sponsor? I understand there needs to be somebody who's a testifying witness, but as between two or more, how is it that your name ended up on this one?
I'm not sure. I'd have to read through all of it. When people give us questions with a lot of subparts, which sometimes that occurs, we have to put multiple sponsors and preparers, and they can get messy when there's a lot of subparts and you don't have clear, succinct questions.
Okay. And while we're in this set of discovery responses, this is would you look at CLC 118, please? Because it's going to go back to your test. I take it, promise this will get us back to your testimony. And is it the company's position first that in case 25-00038 UT, last year's RPS case, the commission's authorizations regarding the Santa Teresa project were limited to 20 years, even though by the time the final order was issued, the company had negotiated an extension to 25 years?
Mr. Hearing Examiner, I apologize. These questions again seem
Is
more
this
like
an objection, Ms. Olson? I'm sorry.
an
Is this an
objection,
objection?
yes.
Okay, please state your objection.
That it's a compound, multi-part, vague question with a lot of assumptions built in that is more like testimony than an actual question.
I'm gonna encourage you, Ms. Stevens, to ask the question in a briefer format or in,
Okay.
sequentially. I was suffering from the same.
Okay.
And so I sustain that objection, and please proceed.
Mr. Novella, does the company, is it the company's position that whatever authorizations it got to use Santa Teresa project in case 25-00038 UT were limited to no more than 20 years?
Let me read this discovery response you're sending me to 118, please. Okay, I read the Q&A. Can you restate your question now?
Okay, yeah. Is the company's position or understanding that the authorization, whatever authorizations it got regarding the Santa Teresa project in last year's case were for a maximum term of 20 years?
I'm not sure. That'd be a better question for Mr. Villalobos. I wasn't in the RPS last year, But looking at this Q&A you pointed me to, based on the response, we're not requesting that in this proceeding here.
And you sponsored, and we're looking at this discovery as you responded a statement that the reference modifications were not requested by EP in this proceeding. Is that right?
That's right.
But you don't know whether, am I to interpret your answer now is that you don't know whether there was a need to make that request?
We're saying that we're not seeking them.
Okay.
With regards to how the approval worked for the previous case that I was not a part of, that'd be a better question for Mr. Villalobos, since he was a witness.
Well, so I would like you to now, we talked at the beginning about your being kind of the leadoff batter and the company's representative in this case. Can you tell me exactly what the company believes was approved in case number 25-00038 UT regarding the Santa Teresa project?
Sure. My understanding is that we got approval of the facility, PPA, that had a solar and battery component, that we got the full solar component approved for New Mexico is 150 megawatts of solar, and we got 50 megawatts of battery. And we're looking to get the remaining balance of the capacity of the battery, which is 100 megawatts, and give those to our New Mexico customers to dedicate the entire STP, or Santa Teresa project, to our New Mexico customers of 150 megawatts solar and 150 megawatts of battery.
And you spoke rather quickly there. Did you say that there's approval of the facility or the facilities?
A majority of it, all of the solar and 50 of the battery, or what we call BESS, BESS. Here with the remaining 100, we'll have the entire facility now for our New Mexico customers.
And did you say that the commission approved the purchase power agreement?
I wasn't in the previous case, but my understanding when it was submitted, obviously a PPA and an ESA for the facility were introduced in that filing. And so that was part of that record and analyzed and looked at and approved when those resources that I just described were approved for our New Mexico customers.
So you're assuming and do not know specifically whether the commission approved the entire PPA and the entire ESA. Is that right?
The way I read it, and my understanding is it's an approval of the facility because they have to do their due diligence regarding the facility and the costs and whatnot to make sure that it's a good resource for New Mexico. And they did that in that filing where they approved, again, all of the solar and a portion of the battery. And here we're just seeking the remaining amount of the battery, 100 megawatts, to give the full facility now to our New Mexico customers.
And I'm a lawyer and you're an economist, Mr. Novella. When you say facility in this context, are you talking about the physical stuff on the ground or the physical stuff plus the contracts that transfer use of that physical stuff to El Paso Electric?
When I say facility, I'm meaning on the ground, the actual physical
Okay, that's it.
facility.
So in this case,
Parties,
what
I
changes?
apologize, Ms. Stevens, I apologize. There's never a perfect time. But I've been holding for a minute to have a break. I think it's now is as good of time as ever. So I'm going to take a 10-minute break and then you'll be able to proceed with your questions. We're going to return at 10:46 a.m. Everybody, please remember that the Zoom will still be, the YouTube will still be live. And so I suggest that you both turn off your video and your audio. And we'll see you at 10:46 a.m. Thank you, everybody.
Mr. Getko?
Yes.
Can you tell me what your count is on how much time I have remaining? Because I've not been able to keep track.
I started my clock at 1 hour and 10 minutes ago. I wrote down when I took a break to discuss objections with my co-hearing examiner and I reviewed that discussion. It was 10 minutes. So I see you as using 1 hour of your time thus far.
Okay, thank you.
Thank you.
Mhm.
I'll give everybody a minute or two, just a few seconds here to filter back in. Okay, welcome back, everybody. It's 10. We're gonna go back on the record now. It's 10:47 a.m. We've returned from our morning break, and the city of Las Cruces will continue its cross-examination of Mr. Novella. Please
Thank
proceed,
you,
Ms.
Mr.
Stevens.
Getko, and hello again, Mr. Novella. Before, I'd like to just finish up where we were with just one or two quick questions. You were telling me what you believe that the company got approval of in the previous case, and what changes or additions is EPE asking for in this case? I guess I could say, is EPE asking to increase the BESS to 100 by 100 megawatts?
We have a lot of requests in this case. It's outlined in my testimony with regards to different treatments we want. With regards to the specific Santa Teresa facility, we're seeking to get approval for the remaining integrated 100 megawatts of battery storage. So it'll add to the 50 megawatts the commission approved last year. So now we'll have the entire facility dedicated to New Mexico.
But you testified before the break that you're not asking to extend the duration from 20 to 25. Is that right? 25 to 25 years?
That's right. Not in this proceeding. My understanding is it was approved for 20 years last year. We're not seeking to move it to 25 in this proceeding.
Okay. And you are asking for a number of changes in rate recovery, right?
That's right.
Which don't directly go to the procurement of resources, just cost to recover.
I'm sorry, don't go to the
Don't go
procurement
directly to the question of procurement of renewable resources. Is that right? So
You trailed off a bit at the end. Do you just mind restating that?
the other requests in the application relate to various ways of rate recovery and reconciliation of existing rates, and don't relate directly to resource procurements. Is that correct?
Generally, I believe so. That's right.
Could you turn to page question 13 on pages 9 to 10 of your testimony?
That would be my direct or rebuttal?
Direct. And
what was the question, Council?
okay, so the question is,
And I'm sorry, Council, the question you were referring me to go to?
Oh, 13 on page 9, continuing on to page 10, Q13.
Thank you. I'm there.
And I'm looking actually on page 10, the paragraph begins on line 8, which refers to the EPE having the ability to differentially allocate more resources through acquisition of system renewable resources. My question to you simply is, does El Paso Electric consider the Santa Teresa project to have been procured or acquired as a system renewable resource?
I'm not sure how it was originally requested or procured. I know our intention is to make this 100% dedicated to our New Mexico customers. So it would not be a system resource, but a dedicated resource or facility for New Mexico.
And are you familiar with the testimony in the previous case offered by the company at all?
Generally, again, I wasn't in that case.
Okay. And are you familiar with Mr. Oliver having testified in that case about the Texas RFP?
I'm not familiar with RFP. in detail. That wasn't done under my purview, my responsibility, or my team.
Okay. So do you believe that the STP was selected in a procurement for Texas, for New Mexico, or for both jurisdictions?
Mr. Hearing Examiner, I object.
Your objection, Ms. Olson?
I object that these questions are outside the scope of Mr. Novella's direct testimony that they're improper cross, and I also object to the extent that these questions are not relevant because they're relating to issues that were presented and litigated in the last REA case. And I would suggest that to the extent there is any relevance that's outweighed by confusion of issues, talking about proposals and approvals from the last proceeding that have already been litigated and decided by the commission's final order, as opposed to the proposals at issue in this proceeding.
I'm going to overrule the objection, given that the resource that was approved in some manner in the prior case is central to the current case. You may proceed, Ms. Stevens.
So let me see. So I think I was asking Mr. Novella whether that the acquisition of the Santa Teresa project was done through an RFP intended to acquire resources for Texas or New Mexico, or for both jurisdictions.
But Mr. Hearing Examiner, I apologize. Can I just ask one clarifying question?
Yes, Ms. Olson.
So to the extent that Ms. Stevens is asking about what was proposed last case and what the commission's ruling on in last case, is that what you've overruled, so she can ask Mr. Novella about what EP's proposal was in last year's case and the purpose of that RFP?
I believe if I go back to the real time, the question is as to Mr. Novella's knowledge as to how the Santa Teresa project was acquired. That was considered in 2025, and so what I ruled on was that it was relevant to discuss or ask questions as to the knowledge that Mr. Novella has with respect to how this project was acquired.
And so the clarification, I guess, is when we're talking about how this project was acquired, are we talking about the project that was proposed in last year's case, or the portion in this year's case?
I don't think I need to answer that question. The Santa Teresa project is a term that's being used throughout. The facility was a term that was discussed. I'm not going to provide that clarification. I'm sorry, Ms. Olson. You can proceed, Ms. Stevens.
Okay, thank you. Again, can you answer the question, Mr. Novella? I know this is getting really tiresome and difficult for you to wait, but can you answer that question about whether it was the Texas, whether the RFP was for Texas, New Mexico, or both jurisdictions?
I don't recall. I know there was a competitive solicitation, and this was a project that came out of that. You'd have to ask for Mr. Villalobos. He clearly testifies.
I ask who?
Mr. Villalobos. And I'm getting feedback on my side, isn't it? Why?
You are not the only one. It did just start. I think it may have disappeared now, but let's see.
He can tell you with regards to how it was procured for what state or system. One thing to note is a lot of times when people hear system resource, they think of what we refer to at El Paso Electric an 80-20 split in terms of a percentage. But my understanding last year, we came in well beyond an 80-20 split. We got 100% again of the solar system approved of the facility, 150 megawatts. We got a third of the battery, 50 megawatts of the 150. And again, here we're seeking the other 100. So that is almost more of a dedicated resource than even a system, although they're both using it, because we're not ratioing it out based on that 80-20, just so you're aware. Just some that might be helpful to the court here.
And Mr. Novella, are you familiar with the circumstances under which El Paso Electric Company asked for 150 megawatts of the solar portion?
I don't understand your question.
Do you know why? But just ask it more straight. Why did the company ask for 150 megawatts of solar from Santa Teresa last year?
Yes, you would maybe best ask Mr. Villalobos since he runs the numbers, but my understanding is obviously this is an RPS case where we're trying to integrate and bring in renewable projects to our New Mexico customers. So it makes sense that we're seeking more renewable projects, and us bringing a project like that to New Mexico makes sense as the goals are increasing, and we've just increased to 40% in 2025, and it's going to increase and beyond that. So it just makes sense that you're going to continue seeing renewable projects being proposed in filings like this. So to me, that's clear.
So is that your own, does that reflect your own assumptions, or does that reflect familiarity with the record in case 25-00038?
With regards to 3.8, I've read it. It's been some time. If you want a response with regards to more precision, I would ask Mr. Villalobos since he was in that case, and his team actually runs the analysis on the necessary energy to comply with the RPS goals. So he would be better to respond to the need a year ago, as well as how that facility played a part in that.
And just one last question that I'm going to ask for some guidance from the hearing examiners. Mr. Novella, did you remember you're sort of standing in the shoes of Mr. Schiestel in last year's case? Did you read his testimony in your preparation for your testimony in this case?
Yes.
Okay. And do you recall that he proposed the 150 megawatt allocation just for 2026 on the grounds that because it was going to be available only part of the year of 2026, that would represent the equivalent of a lesser amount of the total capacity? Is that
Objection.
Your objection, Ms. Olson?
Ms. Stevens appears to be testifying to what may or may not have happened in the last case, and also asking Mr. Novella about a proposal which has been superseded by a commission final order. So I would say what Mr. Schiestel may or may not have testified to is beyond the scope of this proceeding, and that the commission's final order speaks for itself on what was approved in the last case.
I'm going to overrule the objection. The witness testified to having read Mr. Schiestel's testimony, and the question is being asked as to the recollection of what he understood from that reading. Please go ahead, Ms. Stevens.
Do you remember the question, Mr. Novella?
Yes, I believe so. I don't recall the details of his direct testimony with regards to that level of detail. It's been some time since I read it. When I probably started writing my direct testimony, I read it. But so I can't tell you the exact proposal that we had at that point in time.
Okay. Do you recall that staff, did you read the final order in that, the orders in that case? There were more than one.
Yes.
Okay. And do you recall that staff proposed a condition to assure that the cost, if the allocation of the energy were to change in the future, that the cost would remain above the reasonable cost threshold?
Mr. Hearing Examiner, I object to this as well.
What's the basis of your objection, Ms. Olson?
Ms. Stevens is testifying to testimony that may or may not have been elicited in a prior proceeding. And it's simply not relevant to this case what parties propose. All that's relevant is to what was ordered in the final order.
I'm going to overrule the objection. We're still hearing questions with respect to testimony that has been read by the witness in preparation for this hearing, and that informs his knowledge with respect to the current application. And given the environment in which we operate, history sometimes is important, and therefore I'm going to overrule the objection and ask Ms. Stevens to be able to proceed.
Thank you. And again, Mr. Novella, do you remember the question, or do we need to go over it again?
Go over it again.
Should probably ask our poor court reporter to read it back. Would you do that, Ms. Gonzalez? Just to give me a little break here, I'll get a little bit of water.
Sure.
Thank you so much. Mhm.
And do you recall that staff proposed a condition to ensure that the cost, if the allocation of the energy were to change in the future, that the cost would remain above the reasonable cost threshold?
I don't recall the details of staff's testimony.
Do you recall having read Mr. Schiestel's rebuttal testimony in your preparation?
I believe so, yes. Generally speaking, when taking a case, I read all the past history, but it's been some time. Generally, I'll start working on these cases months and months before the hearing dates, and more so focus on the current testimony, not so much previous filings and dockets and whatnot.
And when you do that, Mr. Novell, and I don't want to get into any kind of attorney-client privilege kind of stuff, but are you aiming to have both an understanding of what happened in the past and also to maintain some consistency with the past?
I think it's you need to understand the past, but also I want to make sure that we're being compliant with any past requirements from any cases. That's my goals as a regulatory witness, is make sure that we're being compliant with anything that we were ordered to do.
Okay, good.
For example, out of that RPS case, I believe we were asked to propose a cost recovery treatment in the upcoming base rate case, and we've done that, for example. So I'll make sure that we are compliant with items such as those.
And that what you just pulled out was sort of a specifically forward-looking requirement in the order, but you also try to comply with the kind of built-in present requirements, don't you, of the order?
If I understand your question, yes, we're working to meet the 2027 plan, but at the same time be compliant with any past orders that are relevant to this proceeding, which that would have been in that case the formal request to present a cost recovery mechanism for the Santa Teresa project in an upcoming general rate case.
And one of the other requirements of that order, Mr. Novella, was that the company in the future, if it was going to seek to change the 100% or 100% or 150 megawatt allocation of the Santa Teresa solar facility to New Mexico, that it would at least allocate 172,000 megawatts to New Mexico. Do you remember that in the final order?
I object to the question.
On what basis, Ms. Olson?
That it mischaracterizes the final order.
I think this can easily be solved by referencing the final order.
Okay, we've got the final order. Hold on a
So
sec.
objection sustained, and we'll proceed by referencing the final order.
I guess I need to ask, confirm with Mr. Novella, which I believe he's just said in like 3 different ways, but not absolutely directly. You did read the order, the final order in case 25000038, right?
Yes, but again, it's been some time, so we may
Okay.
have to slowly read through this again.
Okay, it's actually shorter than that. If you would look to CSC exhibit number 3, please.
Okay, I
And
have it
while
open.
you're getting there, do you recall from, your preparation that by the time that case was reached the final stages, it was essentially uncontested?
Yes, I believe there was an uncontested stipulation. And in CLC Exhibit 3, where did you want me to go?
Um, go to start, go to page 12 of 22 or PDF page 13.
Just to make sure I have the right document, I got a of 23, not 22.
It's CLC exhibit number 3.
Oh, okay.
Three, not 23 or anything like that.
Yeah, so you're using the bottom of the page numbers.
Oh, the bottom page number of the, yeah. And then the PDF is, at least on my screen, in the little border on the right.
And Council, what page was it of 22?
It's page 12 of 22. You see the heading there about EP's request for flexibility to modify allocation should be denied.
Okay, I'm there.
And if you just read paragraph 46 to yourself.
Okay, I've read it.
So when you began working on this case, Mr. Novella, were you aware both that the commission had approved 150 megawatts of solar from STP, subject to potentially reallocation, and had the company had asked for, and the commission approved 50 megawatts of battery storage? Is that
Objection.
State your objection, please, Ms. Olson. Yes.
Primarily, I object to Ms. Stevens' characterization of paragraph 46, which identifies EPE and staff's position as a ruling from the commission.
I'm going to sustain the objection. Ms. Stevens, please
okay?
make your questions concise and clear without
Okay.
overdue
Understand.
paraphrasing, please.
Okay. Did EPE in that case, last year's case, agree to allocate at least 172 megawatt hours of Santa Teresa solar production so long as it had 50 megawatts of battery storage assigned to New Mexico, or held constant, as that phrase is used there?
Now, I do recall reading this. Now, my reading of this was that EP was going well above this requirement. We're providing a lot more energy than here, so it was a non-issue. EP is providing 150 megawatts of the solar, or all of the solar, so along with the 50 megawatts of the battery. So my reading was there was nothing to change or comply with regards to this proceeding.
But you do not dispute that EPE agreed to a minimum threshold of 172,000.
Again, I wasn't in last year's case. I do recall reading it and feeling comfortable with our approach to this case and that we're being 100% compliant with all the provisions here.
I'm sorry. I do recall reading that and being,
Comfortable that we were being compliant with all of the provisions here.
Okay. Now, that part of the order has a footnote number 43 to Mr. Schiestel's rebuttal testimony in that case. Is that right?
I see that.
Okay. Did you read Mr. Schiestel's rebuttal testimony as part of your preparation for this case?
Yes.
Okay. And do you recall that Mr. Schiestel both agreed to the minimum threshold allocation of 172,000 megawatt hours and suggested that the company would reduce the battery, the PV portion from 150 megawatts to 58 megawatts?
Mr. Hearing Examiner, I'm objecting to this question.
What's the basis of your objection, Ms. Olson?
It's assuming facts, not in evidence. It's asking Mr. Novella to testify based on hearsay about a proposal that may or may not have been made in a prior proceeding. And it's improper cross-examination under Rule 11-611. It drastically exceeds the scope of his direct testimony.
Response, Ms. Stevens?
Mr. Getko, I think that it maybe exceeds the scope of his direct testimony word for word, although the testimony I had him at was this idea of allocation, allocating and reallocating cost of the output and the cost of shared resources. But the bottom line here is that in case number 250038 UT, I'm not trying to hide anything. The company agreed, the staff proposed, the company
Ms.
agreed, and the
Stevens.
commission approved a proposal that was under the RCT.
Ms. Stevens, I'm going to interrupt you.
I
I
know.
understand you're trying to respond to the objection, but you're starting to stray into testifying.
Okay.
Because I'm going to sustain the objection. I'm going to ask you to ask a single part question with respect to Mr. Novella's knowledge as to what was approved or testified to based on his review of the documents from the prior case. And I suggest that as a form for your question.
Okay. And may I then show him the testimony if he says he's
You
reviewed
may.
it?
You may. He has stated
I
that he
will,
reviewed
okay.
that testimony.
So, Mr. Novella, you did testify earlier. I'm so sorry about all these interruptions here, because I know that you would like to focus. But you did testify that you read Mr. Schiestel's rebuttal testimony in your preparation for this case.
I
Right?
did.
And would you please turn to CLC exhibit number 10, which is
Mr. Hearing Examiner, I just want to state the objection for the record that Ms. Stevens is asking questions about proposals that were made in testimony that were not ultimately ordered by the commission. She has not pointed us to anywhere in the final order where these proposals were ordered by the commission. And so my standing objection to this line of questioning is that it's irrelevant and outside the scope of this proceeding.
Your objection is noted. Thank you for the clarification, Ms. Olson.
Mr. Novella, now that with all these objections, you're having time to go find the exhibits. Would you turn to page 4 of Mr. Schiestel's rebuttal in the last case?
Okay, I'm there. I'm there.
And would you agree that that first question 9 refers to staff's recommendation that the commission direct EP to allocate no less than 172 megawatts of
I'm
Santa
sorry,
Teresa's
I'm
energy?
sorry, I'm sorry, Miss Stevens.
Oh, too fast. okay.
Or too mumbly or something. I lost you
Okay.
there. I have the first question refers
First
9.
question refers to staff's recommendation that the commission direct EPE to allocate no less than 172 megawatts of the Santa Teresa project's energy to New Mexico, right?
Mr. Novella, did
Oh,
you
I'm
understand
sorry.
the question?
Are you with me?
Apologies, I thought that was for Miss Gonzalez, for the court reporter. Okay, I'm at Q9. Did you want me to read Q9? What's your question?
No, I just wanted you to agree that the first question on question 9 refers to staff's recommendation. Is that correct?
I need to read this.
Yeah, please
Let me
do.
read the response and the question on Q9. Okay, I've read it.
Okay. And your answer, and would you say, yes, staff made a recommendation about allocating no less than 172,000 megawatt hours of Santa Teresa annually?
Based on what I'm reading, that's what Mr. Sheetzel looks to summarize from staff's testimony,
And
lines 3 to 4.
and at page and going down to question 10, which asked, does EPE agree with this recommendation? Was EPE's response through Mr. Schiestel, yes?
Let me read a question and answer to Q10. Okay, I've read question 10, and Mr. Sheetzel answers in the affirmative yes to does EP agree with this recommendation?
And then does the next two sentences of Mr. Schiestel's testimony indicate that staff's reason that EP understands staff's goal of maintaining a levelized cost of energy that is consistent with the reasonable cost threshold requirements?
I'm sorry, I didn't hear a question. It felt like it was just a statement.
Did Mr. Schiestel go on to explain that the reason that in agreeing with staff's recommendation, the company understands staff's goal of maintaining a levelized cost of energy that is consistent with the reasonable cost threshold requirements?
No, I don't agree with your question. You said the word agrees. I don't think he ever said agrees because my understanding is you can go above the RCT, both in the rule and the statute. And so we wouldn't agree with that. I think he's just saying that he understands their point of view as I read this. But again, I'm not Mr. Sheetzel, but
I
so
understand
interpret
that.
this.
And then would you go down to the last sentence of Mr. Schiestel's rebuttal testimony? because this is what's relevant. It says in developing EPE's
But-
next REA plan, EPE will incorporate the threshold allocation as Mr. Dunn recommends in determining a proposed New Mexico allocation for the Santa Teresa project.
Does our hearing examiner object to this questioning?
Please state your objection, Ms. Olson.
Ms. Stevens has not sought to introduce this evidence. She's simply reading statements into the record, which are hearsay and not admissible, and offering them for the truth of the matter asserted. She hasn't provided any way to get this evidence into the record, and it's prejudicial for her to be able to read purported statements into the record that have not been introduced by the company and are not evidence in this case.
I'm going
Mr.
to
Gecko?
overrule the objection because she's only asking whether this witness has seen this information. It's not being offered as truth for the matter that's before us currently. So I'm going to allow the questioning for the purpose of recollection and impeachment and distinguish that from factual insertions into this record.
And Mr. Hearing Examiner, I would
Mr.
just clarify that I don't think that she can use testimony from another witness for purposes of impeachment. It's not impeaching any statements that Mr. Novella has said.
Ms. Stevens, did you have a statement that you wanted to make as well?
Yes, yes. First of all, Mr. Novella is testifying here. We will get to it later. He's testifying to questions of law and policy and regulatory policy as the company's regulatory policy expert. Just a year ago, less than a year ago, probably, Mr. Schiestel was in the same position for El Paso Electric Company. And I would be delighted. I will make a request right now to take administrative notice or to admit exhibit number 10 into evidence, because the administrative notice rule says that you can take part of the record of a case, and this was admitted in the previous case. But the gist of this really is that as Ms. Olson objected to the very last sentence, EPE's policy witness testified right there on lines 17 through 20 that in developing EPE's next REA plan, i.e. this case, EPE will incorporate the threshold allocations as Mr. Dunn recommends in determining a proposed New Mexico allocation for the Santa Teresa project. That was the company's position a year ago, and now the company's position appears to be we're going to. I was going to ask him what he interpreted that to be. I have follow-up questions on that, but I certainly want to know how EPE's policy about complying or not complying with the RCT has changed in the last year, when, to the best of my knowledge, neither the rule nor the statute has.
But Mr. Hearing Examiner, may I briefly respond?
I'll allow one more response from each of you.
I object to Ms. Stevens being able to testify to what EPE's position may or may not have been in the last proceeding. I also think it's inappropriate to allow Ms. Stevens to give those statements out of context and without context of what was actually ordered by the final order. Again, EPE's proposals or testimony are superseded by what was ultimately ordered by the commission in that case, and EPE is not bound by what it provided in 2026 for informational purposes to this case. And I would encourage the tribunal to focus on what's actually presented in this case instead of relitigating the 2025 case.
I'm going to sustain the objection with respect to the testimony that may have been provided in response to your objection. With respect to the objection as to referencing the past information, the witnesses testified to reviewing this information in preparation for this case as a basis for understanding the positions that EP will take. Given that understanding, I think it's proper that questions can be asked to this witness as to his understanding and his preparation for this case and how that informed his testimony and his knowledge with respect to both EPE's policies, actions, and proposals in this case. On that basis, I'm going to allow Ms. Stevens to continue. And
I'm not sure exactly what point I'm continuing at. I think I did make a request to take administrative notice, and I don't think you're granting that. But maybe you are. And if I may respond once more, because you said we would each get a chance. I am concerned that this whole case is a proceeding under the theory that EPE can ignore what it told the commission under oath a year ago and can change its interpretation of the rules, the orders, whatever, at will, which seems to be the direction this is heading.
so a couple things. The responses and the statements of the objections are going too far generally. Both counsel are starting to use that space to make
Arguments.
large arguments. So let's all do our best to try not to do that. I understand it's not super simple right now. Second, the questions with respect to the documents that the witness has reviewed to prepare for this case that have informed his preparation for this case are available to help provide recollection and an understanding of how this witness has presented his testimony in this case. Therefore, objections with respect to the understanding that this witness has with respect to Mr. Schiestel's rebuttal testimony or other prior testimony are not going to be immediately granted on the basis that they were in another case from that other individual. This witness has testified to the value of these documents for this matter and the preparation for it. On those grounds, Ms. Stevens, you can proceed with questions that ask questions with respect to the preparation for this case and how that has informed the testimony and knowledge that this witness brings to this matter. Thank you.
Thank you, Mr. Hearing Examiner. The question I was asking Mr. Novello, who's probably wanting to kill us all at this point, is that last sentence of Mr. Schiestel's rebuttal testimony on page 4, which says, in developing EPE's next REA plan, EPE will incorporate the threshold allocation as Mr. Dunn recommends in determining a proposed New Mexico allocation for the Santa Teresa project. Did you attempt in developing this case, both personally and as a team, to follow through on that assertion in Mr. Schiestel's testimony last year?
So to answer your question, I read all these documents as preparation, but what I really put weight on is the final order, because those are what I consider to be our marching orders. Now, when I do read direct and rebuttal testimony, I have to look at those in the light of those are worlds that are static in nature and have changed. So I don't look at past testimony before an order and do everything that's outlined in that, because things change and develop in the course of any proceeding. So with regards to your question, I've read this testimony, but more so as to what I do to make sure we're compliant with the case, it all follows the final orders of that proceeding.
And I'm trying to find the term. So do you read the final order as, in that case, in 25-00038, as incorporating, this is paragraphs 46 and 47, and paragraph F with the conditions established in this order. Do read this order, and by you, I mean you personally and the company at this point. Do you read this order as incorporating that the staff's threshold analysis or not?
Let me look at it. What exhibit was the final order again?
Exhibit 3. I hope.
Okay, and you said ordering paragraphs 46 and 47?
46, 47, and then going to the end of ordering paragraph D about F about condition F.
I'm sorry, you trailed off there.
Oh, then and the ordering paragraph F referring to conditions established in this order.
Okay, let me read that. I can tell you before I read it that I did read this document. I felt we were compliant with regards to anything that was requested.
Oh, I'm sure you
here.
did. Yeah, I know.
So 46, and I'm sorry, I didn't understand you. 46, and I heard through F, so I kind of
46, 40, no, hold on. 47, I think 46 and 47, we go back. 46, 47, and F at the end.
Okay, let me read those sections. And where is F? What page? Make sure I'm on the.
Near at the back of page 20 of 23 PDF, page 19 of the order. No, take that back. It's page 19 of the PDF, 18 of the document at the footer.
Okay, I've read it.
Okay.
And your question?
So do you, when you sat down to work on this case, did you understand, having read at least Mr. Schiestel's testimonies, I think you testified, maybe not staff's, and also the order here that we're looking at, did you understand that the commission was imposing a condition that EPE should, as long as it kept the 50 megawatt battery allocation, allocate at least 172 megawatt hours of solar energy from the solar PV facility over prospectively?
Yeah, my reading was this was a non-issue since we were supplying 150 megawatts or all of the solar facility. So you can't do more solar than what we're proposing here. So the way I read this as a minimum was something that we weren't broaching. Now, if we were to supply much less than what we're supplying now, say under this level, then it was something that it may provide a pause that we had to provide an additional analysis. But my reading was that we were being compliant with this. We're providing every single kilowatt hour associated with the solar facility. So this was complied with regards to this filing.
And I know that was a yes, but I'm not entirely sure it's a yes to my question. The order here was about flexibility, looking at the first phrase of paragraph 47, flexibility above the minimum threshold allocation. So are you saying that the commission did not recognize a minimum threshold allocation?
The way I read it, and I recall some back and forth on this topic, and it's been a bit hazy since the time has passed, was that there was this minimum language, and I read through the minimum language, but since we were seeking or are seeking and have gotten approval for all of the solar facility, that it's not at issue here because we are not giving a lower value of the solar, a lower amount to our New Mexico customers. They're getting 100% of the entire solar facility. I read this as a provision, again, for a lower amount that it doesn't play a role here because we're not seeking that lower amount or anything below that value.
And the fact that that lower amount was based on, and if you look at paragraph 46, that it was necessary to achieve the RCT, that's not relevant to you?
Well, it's
Mr.
relevant.
Hearing Examiner, I object to this question. Ms. Stevens is relying on paragraph 46, which states staff's position and EPE's position to somehow elevate that as an order by the commission. It's misinterpreting this order.
And let me review the transcript. And Ms. Oways, I'm reviewing partly because I'm hearing that Ms. Amer is trying to get in, but I do not see her in the waiting room.
Yes, Mr. Hearing Examiner, I was wondering if the device labeled PRC G56, I'm not sure if that's Miss Amer, but I'll try to find out.
PRC. Okay, well. Okay, thank you. I'm going to review this for a second. I'm going to sustain the objection. Ms. Stevens did start to imply certain meaning. Ms. Stevens, you can try to ask your question in a different format.
Differently? Okay. I think we maybe should just move on rather than interpret orders. I would just ask Mr. Novella, let's just, in the cases in which you've testified on annual RPS filings, before this one, has the company ever proposed a procurement that would cost in excess of the RCT?
I don't believe so, but that wouldn't prohibit us from doing so.
Okay. And are you aware of any other cases, the ones that you didn't testify in which the company proposed a new procurement that was in excess of the RCT?
Not that I'm aware of, but again, that wouldn't prohibit us from doing so.
And before one quickie here, I know that this is going to get an objection, but why not give it a try?
Ms. Stevens? Ms. Stevens, it's enough
Yes.
with the commentary around the questions.
Okay.
We've already spoken about that twice.
All right, I'm sorry. Let's see. CLC Exhibit 39, please.
Okay. I have it open.
And this is a discovery response in the pending general rate case, which is not signed by yourself, but you probably do not recognize it. So please, would you look at the response to 6-1I without, we're not going to read it to the record or anything. Just would you look at it, Mr. Novella?
Yes, let me read it.
Don't read it, not to yourself, please, not out loud, so we don't get into objection territory.
It does reference a previous subpart, so it's just going to take me a while to read because that subpart references another subpart, okay? Well, it actually, I is referencing a whole other discovery response. Do you have the discovery response?
Are we in the same
referencing?
place? I'm looking at the middle paragraph of I on page 6 of 10 of CLC exhibit number 39.
All right, for CLC exhibit 39, I
Yeah.
see an RFI for CLC 61. Are we on the same page?
6-1, right,
Okay.
correct.
And you said subpart I?
I,
Okay. It's because
after H,
in the question
I.
I,
I'm
the-
sorry, you're both talking. I can't keep it straight. Try again.
Mr. Hearing Examiner, I am gonna object to this. Again, it's discovery in an active case, and so any questions about it are being transmitted to the public in an ongoing litigation. I also, Mr. Novella is not a sponsor to this discovery response, and Ms. Stevens has not laid any additional information showing that the witness has personal knowledge of the questions, even if she were to just ask the substantive question without referring to the rate case docket or rate case ongoing discovery.
Ms. Stevens, I'm going to allow you to respond before I rule.
Once again, Mr. Novella is in the same role in the general rate case, and he may have direct knowledge of this answer if he says he's never seen it before or doesn't know anything about that. Obviously, this discussion stops, but if he does have knowledge, it's quite relevant, I think, to what's going on in this case.
I'm going to grant the objection. Any question should be guided towards knowledge with respect to what is covered by the document. Mr. Novella did not produce this discovery response, and therefore the reference to it is very tenuous. And so questions should simply be to the witness's knowledge as to the topics that interest the city of Las Cruces. But let's stay away from direct reference to this document in this case. Objection granted.
And I may not have understood that correctly, but I'll ask a question, and if you think it's inappropriate, please tell me, because I think I'm trying to comply what you said. So I'll ask Mr. Novella directly. In the course of, in the general rate case, which case 25-00082 UT, which you're sort of, you're the policy witness for.
Mr. Hearing Examiner, I apologize. I want to tread very carefully into this subject, and I'm very skeptical of Ms. Stevens being able to ask Mr. Novella in this case about questions about positions that are being taken by EPE in a ongoing litigation, the current rate case.
We haven't gotten to a question yet. I understand your concern, but please proceed, Ms. Stevens.
Yeah.
If it gets to a point where it's difficult for you, Ms. Olson, and for EPE,
Yeah.
please lodge an objection, but we aren't yet there.
Yeah.
Thank you.
Well, that was why I was trying to ask him to look without answering, without or even reading it out loud, but I'll
Ms. Stevens,
try.
yeah.
And in the general rate case, Mr. Novella, did El Paso Electric Company, to your knowledge, make any assumptions about how it would proceed based on the order in the REA order in case 250038 UT when it decided how it would allocate dedicated versus system resources for purposes of rate case cost allocation.
Mr. Hearing Examiner, I'm gonna object. Ms. Stevens is directly asking Mr. Novella about EPE's position on allocators presented in the ongoing rate case. This is not directed at a position taken by EPE in this case. This is a question directed to Mr. Novella's testimony and EPE's position in the rate case.
I'm going to overrule. There's testimony in this case with respect to presenting the Santa Teresa project cost recovery in the rate case. The Santa Teresa project is considered in this case. EP has established the connection between the two cases. The question has been made with respect to the public filing of that rate case, not to a particular discovery response. Ms. Stevens, you may proceed.
Okay, Mr. Novella, did you remember the question? Because I think it's the same question still.
Can you restate it, please?
Ms. Gonzalez, would you kind of help me out, please? I'm sorry, we've been at this a long time and haven't gotten very far.
Let me see if I can find it. Let's see, is this the one? In the general rate case, Mr. Novella, did El Paso Electric Company, to your knowledge, make any assumptions about how it would proceed based on the order in the REA order in case 250038 UT when it decided how it would allocate dedicated versus system resources for purposes of rate case cost allocation? So
Yes, so with regards to costs, Santa Teresa, and for the ongoing current rate case, out of the REA final order that came out last year, we were ordered to talk about, and your question had cost recovery mechanisms to address that. So in that proceeding, and by that proceeding, the general rate case that we have going on, we're seeking to move capacity costs for these facilities that have batteries into base rates. So the cost recovery proposal by EPA is to move those into base rates. And obviously in this proceeding, we're talking about the procurement costs associated with energy that we're seeking to put those in fuel or FPPCAC. So out of the previous REA with regards to cost, that's our proposal here in this case.
Mr. Novella, I appreciate that answer, but that's not quite what the question was about. It's about cost allocations, not recovery methodologies. So can you focus on the cost allocations aspect of the rate case?
Sure. So with
Mr. Hearing Examiner, I'm gonna object. Ms. Stevens has clarified she is not asking about cost recovery proposed in this case. She's specifically asking questions about the allocation of resources proposed in the rate case, which goes beyond the scope of what's before you in this hearing.
I'm going to sustain the objection. Ms. Stevens, ask another question. Thank you.
Okay, let's see. Let's move on to your testimony about legal issues, Mr. Novella. And I think we probably, let me see. And I'm at page 15, question 23 of your direct testimony. You with me?
I'm there.
Okay. You're not an attorney, are you?
No,
And do you know that whether even if you were an attorney, you would be allowed in a court or a commission hearing to testify to interpretations of statutes?
my understanding is I could read the statute and give my opinion if we're complying with those statutes.
Okay. And do you know what weight your interpretation of a statute is entitled to under law?
No,
So assuming that maybe your interpretation is entitled to some weight, Mr. Novella, let's unravel your testimony
Ms.
here.
Stevens, Ms. Stevens. No more commentary, please. Questions.
Okay. Would you
And
please
I'm
turn
gonna
to-
lose my patience with it. I'm gonna lose my patience with it. Questions.
Well, I could, do you want me to
No
move to
more
strike
commentary.
first?
Proceed with your next question, please, Ms. Stevens.
Okay, so here and again in your rebuttal testimony, if you want to pull up your rebuttal testimony too, because they're sort of in parallel.
okay. What page?
Let me pull it up because I don't have it open right now, but it's where you start talking about the statute. Oh, it's in the wrong. There it is. Rebuttal. Okay, let's see. It's on page 5 of your rebuttal also. And at page 7 to 8 of your rebuttal. So basically your position, is it correct to say that the sentence about from the Public Utility Act that says that I'm reading now from the rebuttal testimony on page 7, line 19 onto page 8, line 1. Your testimony, I believe, is that the language of section 6216(4)(e) of the Renewable Energy Act that says that the provisions of statute do not preclude a public utility from accepting a project with a cost that would exceed the reasonable cost threshold, means that the reasonable cost threshold is not, as you use somewhere on line 19, does not operate as a hard cap or a strict barrier for approval. That's your position, right?
Yes, and not just that statute citation, but the rule as well. Also
Okay.
clearly states that you can go above the threshold.
And when you tell me where it clearly states that, well, okay, let me ask that differently. Do you agree that that sentence that you quote says that the utility may accept a project with a cost that would exceed a reasonable cost threshold? The utility may accept.
I'm sorry, what are you referencing again?
The same thing that you've quoted in both testimonies, but I'm looking at the version in your rebuttal at the bottom of the very bottom line of page 7 and the top line of page 8.
Says the provisions of references a section do not preclude a public utility from accepting a project with a cost that would exceed the reasonable cost threshold.
Okay, right. Does that statute say that the commission must or even may approve, as opposed to the company may accept?
I don't see anything here stating what the commission has to or doesn't have to do with it. Clearly states that a utility can get facilities that are above the reasonable cost threshold.
And you did accept, the company El Paso Electric did accept Santa Teresa project as a whole, which according to the testimony in this case has a cost as a whole, 150 megawatts solar, 150 megawatts BESS, does exceed
I'm sorry.
the reasonable cost threshold, right?
Ms. Gonzalez, please.
Did you
Sorry,
catch-
I want to make sure I did catch it. So it was 150 megawatts solar and 150 megawatts BESS.
Yeah.
Oh, okay.
Capital B, capital B, capital E, capital S.
I know, I just didn't clearly
Yeah.
hear it. Thank you.
And the company accepted that project or those two agreements back in 2023 or 2024, Mr. Mr. Novell, is that right?
I'm not sure on the date that those agreements were executed. I'm not familiar with that.
Mr. Hearing examiner, Madam Hearing examiner too, she's so quiet. I am going to reluctantly ask the commission to take administrative notice of those contracts, which are in City of Las Cruces exhibits number 1, which is the entire application, and City of Las Cruces exhibit number 2, which is the amendments to those applications. I think that it is important that when we're asking, the company is asking to approve a new resource, that the record in this case reflect what those resources are. And I understand that, exhibit number 1 is much larger than just those two contracts, but I believe that what was discussed at the pre-hearing conference was that we should not be trying to chop up file documents, at least not in terms of uploading them. I don't know in terms of admitting them or taking administrative notice. I would only ask that administrative notice be taken of the contracts themselves. I don't want the whole file, I don't want to take administrative notice of the whole file.
Yeah, I appreciate your recollection of that discussion, and for the purposes of trying to make exhibits manageable for upload, that's a good recollection. And I'm inclined to take administrative notice of the contracts specifically, and maybe a way to accomplish that, given the way that the exhibit exists now, is to use our lunch hour. Thinking on my toes here, to extract simply the contracts from those documents and admit those via administrative notice. I can take on that task and present them to parties, I believe, and see if there are objections to that when we return from lunch. I can share my screen and show what I will label as hearing examiners exhibit number 1 for administrative notice purposes of the contracts. Can you clarify within exhibit number 2, what is there with respect to the contracts that is different than is in exhibit number 1?
It is the amendments that were discussed in case 25000, which mostly have to do, at least as the sort of relevant portion or significantly relevant portion, are that the amendments change the lifetime, the duration or term of the contracts from 20 to 25 years, which has an impact and some slight relevance, very slight, to the calculation of the RCT. Mr. Novella already has testified that in this docket, the company is sticking with the 20-year term that the commission approved in 2500038 UT.
Mr. Hearing Examiner, may I briefly respond just for helpfulness?
Yes, please, Ms. Olson.
All of these documents are filed in 2500038. If it's helpful to the hearing examiner, I can send you a PDF of the PPA and the ESA that were attached to Mr. Villanueva. You got me mixed up on that now.
I'm sorry, the PPA and the ESA that were attached to
Mr. Villalobos's testimony in that case, which are the executed agreements. I'm happy to send those to you in isolation over the lunch break. And then as far as the amendments, if you're taking administrative notice, just for purposes of completion and clarity, I would ask the commission just use the notice of filing that was submitted in 2500038 instead of the documents in isolation. So to have that complete filing that has the cover pleading and the amendments that were attached to that filing, because that's what was filed into the record. Into the docket.
And Mr. Hearing Examiner, I think she's are you agreeing that you like the way CLC exhibit number 2 looks in terms of capturing the amendments? It is the as filed notice.
Sorry, I was showing up differently in my preview. But for purposes of taking administrative notice, CLC exhibit number 2 is fine. And if it is helpful to you, I can just send you the exhibits to Mr. Villalobos's testimony.
I appreciate that, and I think we've reached a perfect resolution on that. Right now, the hearing examiners will take administrative notice of what is labeled as CLC exhibit number 2 underscore docket number 25-00038-UT underscore notice of filing STP amendments. STP amendments is in brackets there, Miss Court Reporter. And then upon the return from lunch, we will review the document that Miss Olson has kindly offered to send, and then we will proceed from there. It's 12:05 p.m. Does anybody have an objection to taking a full 1 hour and returning at 1:05? Hearing none, we're going to go off the record for lunch. Remember that the YouTube stays on. Please, very first thing you do right now, turn off your camera, turn off your microphone, and then I hope everybody has a nice lunch, and we'll see each other at 1:05. Thank you.
I thought about
Might be
John.
good.
Let's see. Welcome back, everybody. I've just got to do one thing, get my real time rolling again. Okay, well, let's see. I'm gonna relaunch. I don't know why it's doing this to me. Sorry. Let's get let's do this one. Okay. Welcome back. I hope everybody had a nice lunch. Well, I'll deal with that when we go back on the record. Is there anything off the record that needs to be discussed right now that might be brief? Otherwise, I think everything that I have to say might be most appropriate at the start on the record.
Mr. Hearing Examiner?
Yes,
I just
Ms.
wanted to
Stevens.
check in whether, I think you said you would the hearing examiners would take care of I'm not sure, the relabeling of the exhibits from over the weekend. Was I supposed to do that or you?
Oh,
I know I
piece.
don't have access to the Dropbox.
On that piece, I don't recall what I said at the start. I'm sorry. I could,
I don't think I was supposed to do it because I think I would have remembered, but I think we don't have a plan because it turned out that EPE's regulatory staff had given the document to Mr. Novella, but I don't know whether that may be a problem with subsequent witnesses.
yeah, why don't I commit to renaming that? I've got access to the Dropbox and I'll do that over the afternoon break unless that's too late. If anybody says we need to wait to go on and I go shut down for 5 minutes here and rename those and upload them. Would people be okay with me doing that over the afternoon break?
Mr. Hearing Examiner, can I just ask one
Yeah.
clarification with respect to CLC Exhibit 1? Are we intending to replace CLC Exhibit 1 with the PPAs, or Ms. Stevens, are you considering continuing to use that for a different purpose?
Um, I think the answer is I hope that, want the revised Exhibit 1 just so that it has the pagination that went missing for cross-examination purposes in terms of actually admitting at the hearing examiners. We're just going to prepare for administrative notice the two contracts out of there. So not to be admitted, but just to make it easier to work with, at least at this point.
Yeah, understood. I guess my thought on that is that it might not be worth anyone's effort to go through changing much because it's not going to be an exhibit in the record. So I defer to you, hearing examiner, whatever is easiest for you.
Well, right now I'm realizing I'm confused. We had the two contracts that we discussed right before lunch. And this is what I was going to do on the record, but we can do it again. So the two contracts I've labeled as hearing examiner exhibit number 1 and hearing examiner exhibit number 2. They are currently on the Dropbox. So thank you for sending those, Miss
Ooh.
Olson.
So we need to go back to them.
And so that's where the contracts are, the STP PPA and the STP ESA. So that matter, I think, is taken care of. The other matters, yes, Miss Stevens?
What about the CLC exhibit, the amendments to those two agreements that we talked about that Ms. Olson agreed should go in kind of as they are in CLC 2 with the cover pleading in case 2538?
Well, we admitted CLC exhibit number 2 right before lunch, if I remember correctly.
For
I-
And that
administrative
was,
notice.
For administrative,
we
for
didn't admit, we took
administrative,
administrative
okay, so
notice of
it's
that
admitted, it's
document.
admitted as that wasn't, okay, I guess I kind of missed that.
And so
We actually
now,
admitted
when
in
we
that
go back
form.
on the record, I'm gonna take administrative notice of hearing examiner exhibit number 1 and hearing examiner exhibit number 2. And then what I'm proposing is over the afternoon break, I will go back to the transcript and understand exactly what I'm doing with the 2 documents that were sent this weekend by the city of Las Cruces. And make sure that those are labeled properly. And then after that afternoon break, we can have another small discussion like this and make sure we're all on the same page. Partly just because my memory of exactly those 2 documents is a little bit fuzzy at the moment. But that's a decision that I'm only going to take if, there isn't an objection to that, because the other option is, I pause this thing, the Zoom for 5 more minutes and I go back to the transcript and I deal with those 2 documents that we discussed this morning and that were sent over the weekend.
I don't object to relabeling them.
Thank you, Ms. Olson. Ms. Stevens, since those were documents that you emailed, and you're performing the cross-examination at this time, do you have any objection to my doing that relabeling and placing those on Dropbox over the afternoon break?
I don't, on the condition that, as I kind of inferred from Mr. Novella, that the EPE witnesses at least have the version with the pagination. I mean,
Yeah,
so we don't have
and
to sit here looking and there's,
that helps me remember.
there's no numbers anywhere.
Yeah, that helps me remember
it's
that.
for convenience.
That helps me remember that Mr. Novella clarified that at the start of the hearing this morning, that he did have access to those documents because of the regulatory case team. So, great. Okay. With that, I appreciate the discussion. I'll put a big piece of paper on the floor so when I go to walk out the door, I will see it and it says relabel exhibits. And we will go back on the record. Okay, good afternoon, everyone. We are back on the record in the public hearing day 1 for 26-0000093. When we left off before lunch, I committed to receiving the Santa Teresa project PPA and ESA in an email from EPE's council. Ms. Olson kindly emailed those to me. I relabeled them and they are uploaded to our Dropbox as hearing examiner exhibit number 1, which is the Santa Teresa project PPA that was attached to direct testimony in case 25-00038-UT. And there's also hearing examiner exhibit number 2, which is the Santa Teresa project ESA contract. I will take administrative notice of those 2 documents at this time, hearing examiner exhibit number 1 and hearing examiner exhibit number 2. Off the record, we also discussed that a remaining task for the hearing examiners is to rename and upload to Dropbox the 2 documents that were emailed by City of Las Cruces this weekend and that we discussed at the start of the hearing this morning. And that is going to take place on our afternoon break, which brings us to the next slight topic, which is we'll of course take an afternoon break this afternoon. You know, I don't anticipate at this time going past 5 o'clock. There could, you know, be a circumstance where we're just that close to finishing. But if it's not just that close, I'm inclined to reconvene in the morning and have an evening to regenerate. The other matter I wanted to bring up, and this could be helpful for you, Ms. Stevens, is currently I have your allotted time that you have used 2 hours and 20 minutes.
Okay.
Hearing examiner Lecoq and I discussed over lunch that given the amount of time that we've discussed on certain objections, we aren't going to be exactly hard with the 4.5 hour deadline on that, but we won't be looking at extending more than kind of a rough 10 to 15 minutes, depending on how questioning goes, because objections are a general part of how this goes. That's our current assessment. I reserve the right to adjust depending on how the hearing proceeds this afternoon, but that's where we currently stand.
Thank you, because I'm completely incapable of keeping a good track of any of this.
I understand. Is there any other matter to raise before we return to the cross-examination of Mr. Novella by City of Las Cruces? Okay, hearing none. Welcome back, Mr. Novella. And Ms. Stevens, you may proceed with cross-examination. My understanding is that Mr. Novella continues to be under oath.
Good afternoon, Mr. Novella. We're going to make this a lot faster now. And I think that we were at the point of looking at your testimony, your direct and rebuttal concerning the RCT provisions, renewable cost threshold provisions, and also the statute. Do we have the statute open at the time we separated?
No, we were looking at my testimony that
Okay.
pulled an excerpt from the
Right,
statute.
okay. So would you look at
Hold an
CLC
excerpt from what? I'm sorry.
From my testimony,
Right, okay.
I'm sorry, an excerpt from the statute that was in my testimony.
So would you please refer to, open up CLC exhibit number 28, which is labeled the Renewable Energy Act 2021.
Okay, I have a CLC exhibit 28 open.
Okay. Now what you were quoting from or referring to in your testimony, Mr. Novella, is section 6216 4E, correct?
That's right.
And if you would turn, this is it's on page 6 of the PDF in this exhibit. And Mr. Hearing Examiner, this was one of the compilation commission exhibits that didn't come with numbers.
Okay. Thank you.
Okay. So if you're looking at section E, would you agree that the language that you quoted, the provisions of this subsection do not preclude a public utility from accepting a project with a cost that would exceed the reasonable cost? That's in the middle of that.
I'm sorry, I'm sorry.
Okay, the provisions of
Include a
the
public-
subsection.
Okay.
The provisions
Go ahead.
of this subsection, the provisions of this subsection do not preclude a public utility from accepting a project with a cost that would exceed the reasonable cost threshold. Before we took a lunch break, we were talking, we were discussing the fact that the word accept in that sentence is not the same as commission approval. Now I'd like you to then we were going on to whether the company accepted the Santa Teresa project when it signed the contracts, and then we went off to the discussion about admitting the contracts into evidence. Did you have a chance to look at the contracts since comments during the lunch break or anything?
No,
So, would you accept subject to check that they were dated November 18th, 2024?
I don't know the date. I'm not familiar with when they were executed.
Okay. And do you know whether El Paso Electric became irrevocably bound when it executed those agreements? This is probably a question for your lawyer.
Yeah, I'm not an attorney. I'm not sure
Okay.
exactly. I
Mhm.
can't answer that question.
Okay. And so let's go back to looking at the statute. So what you quoted is that middle sentence here. I'd like you to look at the first sentence. Don't read it out loud. Don't say anything. Just have you
Okay.
okay, did you consider that first sentence when you came to the conclusion that the middle sentence allows a utility to go above, allows the commission to approve a resource that has a cost that exceeds the RCT?
Yes, I believe we try to take all of the statutes and rules into account.
Was that we meaning, was that the royal we or the collective we?
As a utility, definitely that's something that we strive for.
I didn't think you were a sort of royal we type individual, Mr. Duval. Okay, so and the same, was the same apply, excuse me, does the same apply to the sentence that follows? Excuse me, your sentence.
Yes,
When a public utility can generate or procure at or below.
yes, just that we try to take into account all aspects of the rules and statutes that govern
Okay.
the cases that we're in and making sure we're in compliance.
And you still came to the conclusion, you collectively came to the conclusion that it was appropriate to ask to go over in this case.
Yeah, I think we clearly see that the statute and the rules allow utilities to have facilities that are above the RCT if they justify them. And here we're clearly justifying them in the testimony of Emmanuel Villalobos with very specific reasons why this is in the best interest of our New Mexico customers.
And let's look at a different part of the statute, would you? Because this relates to your rebuttal testimony when you start talking about the Supreme Court opinion. Would you look at section 6216.2, which starts on page 1 of the PDF, but the text is on page 2?
Okay, I'm there.
Okay. And section B of section 6216.2 states that the purposes of the Renewable Energy Act are, and lists 3 of them, purposes. And the third one is the one that I'm interested in, and that it reads, protect public utilities and their ratepayers from renewable energy costs that are above a reasonable cost threshold.
I'm sorry, did you say D?
D3, B3. B3, got it?
Yeah, so I'm there now. Can you restate what you're referencing?
So does the Renewable Energy Act there specifically say that one of the purposes of the statute itself is to protect public utilities and their ratepayers from renewable energy costs that are above a reasonable cost threshold?
I see that wording on B3.
Okay.
Obviously, there's been amendments done and changes so that utilities can come if they justify it, so that they can seek facilities that are above RCT. And in this case, that's what we're doing, one that's marginally above. And again, what's in the public interest for us to get that facility approved.
And I assume that you also looked at, I know, but you looked at Rule 79, 572, the Renewable Energy Act rule, right?
I'm sorry, can you, I heard you say
CLC
572.
Exhibit 30, it is the Rule 572.
Yes, I've read over Rule 572.
Yeah. And would you look at the definition of renewable? Have you opened that up? Could you open that up, please?
Which exhibit is it?
30, CLC 30. And I'm on page 4 of 16, definitions beginning with the letter R. And the definition number 1.
Okay, I'm there.
Okay. Would you agree that the commission added or interpreted reasonable cost threshold in this rule as the reasonable cost threshold is a customer protection mechanism that limits the customer bill impact resulting from annual Renewable Energy Act plans?
I'm gonna
That's
object.
Do you objection, Ms. Olson?
If Stevens is asking about a commission interpretation of the rule, I'm objecting to the question as vague.
Ms. Stevens, can you restate your question, please? I'm gonna sustain the objection.
Okay. When the commission defined or summarized its definition of reasonable cost threshold in the rule, did it also choose to assert that the reasonable cost threshold is a customer protection mechanism that limits the customer bill impact resulting from annual Renewable Energy Act plans?
That's what I'm reading on this page.
And did you take that into consideration when the company proposed to add $15.54 million per year to the cost recovery for annual Renewable Energy Act plans for the Santa Teresa extra 100 megawatts of BESS?
Yes, we definitely think about our customers' bill impacts, and again, this speaks to how we really believe in this asset. It's at a great price. Prices are only escalating. So when we think about this comment right here, and I think in their thoughtfulness, there's added language beyond that again lets utilities go above the RCT, that we're trying to bring in a resource that's helping on a variety of levels. And ultimately, at the end of the day, it's doing what we need to do to help our customers, giving capacity, reducing curtailments, bringing in energy arbitrage. So there's fundamentally a lot of benefits to our customers and ultimately their bills as a result of this resource. So we're really hoping to get this approved, and I think this speaks to that.
So, Mr. Novella, the company has an RFP outstanding for new resources for New Mexico right now, doesn't it? Under the integrated resource planning process?
I'm unfamiliar on the current status of that RFP. That's led by Mr. Villalobos' team. He could answer exactly what status of that is currently.
And since you're the policy company witness, the company's policy witness, pardon me, I'll ask you to just hypothetically assume that the date for submitting bids into that RFP, that there is an RFP and that the time for submitting bids has not passed, okay? So just those are hypotheticals. I'm not asking you to confirm that. And assuming that that's true, couldn't the company propose this excess portion of the BESS that right now it doesn't have a home for and actually have it competitively compared to other available resources through the RFP process.
Is there an examiner object?
Yes, Ms. Olson, please state your objection.
I think this is inappropriate cross-examination under Rule 11.6.11. It outside the scope of his testimony. I don't think that Mr. Novella has talked about a hypothetical future RFP with a hypothetical closing date. And I also object to the question as compounding, including a ton of assumptions that are not facts and evidence.
I'm going to sustain the objection in part for the commentary as to what the hypothetical might represent with respect to the hypothetical and general RFP processes, given the testimony in this case regarding RFPs and the role that Mr. Novella plays. I will deny the objection with respect to the ability to ask a question properly stated with respect to that hypothetical. Ms. Stevens, please proceed without commentary and provide your question again.
So I think I can, assuming that the way things currently structured at EPE have an open RFP process for additional capacity of all sorts from all types of bidders, would it be possible for the company to essentially bid in, self-bid, whatever you want to call it, this 100 megawatt section of or component of the Santa Teresa project BESS that presently is not dedicated to New Mexico?
Yeah, I don't believe that would be prudent. Right now, the need is here and now. Just a few weeks ago, EP hit a new records peak in its history, 2,394 megawatts, I believe. This week, we may break it again. And this is without data centers. Our organic customers, our natural, mom and pop shops, our residential customers are growing. Our New Mexico
Sorry, I
customers.
need you to just go a little slower for me.
Sure.
This we may break it again.
Yeah, we may break it again with our organic customer load, our residential, small commercial, and I said mom and pop shops. What you're seeing is tremendous growth from our typical base. This is without data centers happening now. This is a new record that just occurred. And again, I expect maybe another one this week. And we have this tremendous load growth, and we have a great capacity at a great price. What I would hate is for our New Mexico customers to lose out on that when there's a tremendous need for capacity and a capacity resource that helps us hit REA goals. With intermittent resources taking a greater and greater share of our overall mix, we need base load or generation that we can use into our peak hours. So no, I think we can't wait. I think it's prudent to move now and get our customers a well-priced resource that helps them now.
You're not going to be able to get under this docket, Mr. Novella, is the company expecting an order by the end of this year, in the fall, after the summer season? Let me put it that way.
So for 2026, I would expect the final order after our peak summer season in 2026.
And if the company could if the company is requesting bids for 2027 and thereafter capacity in its IRP, it's pending RFP, would that resolve your concern that it must be done now?
No, there's tremendous growth in New Mexico. I would like our New Mexico customers to benefit. Every day, it feels like a week, we're being contacted by people that want generation on our grid. And I want this to be reserved for our residential residential commercial customers in New Mexico. I'm not sure exactly what alternatives there are, or if there's been anything thought about, and that may be better questions for Mr. Villalobos, but I would prefer this type of resource to stay in New Mexico.
In the meantime, I guess it just came on, but can you tell me how EPE is utilizing or planning to utilize the 100 megawatts that is currently not in the New Mexico RPS portfolio?
How it will be operated, it's beyond the purview of my responsibility. I'm not exactly sure, but what I can tell you, it'll really complement solar. Obviously, being able to be store energy when prices are low and being able to export it when prices are higher to benefit our customers. I expect there to be a lot of that type of energy arbitrage used. Again, that'll benefit our customers is the way I expect it to be deployed. Beyond that, I would ask Mr. Villalobos more operational questions.
Okay, I think that, hold on a second here. Let's go to your testimony about Rule 551 as an alternative means of approval. And I know that you were asked by staff to sort of clarify how EPE viewed Rule 551 as an independent basis for approval of the BES, and your answer on page 6 of your rebuttal leaves me a little uncertain as to whether, and the following questions leaves me a little bit uncertain as to whether whether the company's position as expressed through you is that the company is requesting Rule 551 approvals in this case if the commission doesn't approve under Rule 572, or whether you're seeing that as an alternative pathway, because specifically the phrase is on page 7, lines 1 through 4, alternative procedural pathway phrase. What do you mean by that?
I'm sorry, I'm not finding.
And that was too long of a question, but if you just look at page 7, lines 1 through 4.
And with regards to the pages, are you referencing the?
I'm referencing the page
13.
numbers on your testimony at this point because there are page numbers. The PDF is 9.
Okay, so I'm there, page 7, 9 of 13. Where exactly again?
At the very top. However, if the commission does not accept this position, that sentence.
Okay, and what is your question?
When you refer to Rule 551 being the available alternative procedural pathway, can you explain whether you mean in this docket or in a separate docket?
In this docket, we believe, in reading staff's testimony, I think they believe as well, this type of resource falls properly under 572. Now, we wanted to give an alternative pathway if the commission felt otherwise, that it wasn't properly assigned to 572. We gave all the data needed to it to be assessed under Rule 551 or the approval for purchase power agreement. So we've provided everything under 572, which we believe this is the proper home to get this facility approved. However, in the case that the commission wanted to look at it through the lens of 551, we've provided that as well.
And in your direct testimony, Mr. Novella, didn't you, and I'm on page 16 of EP Exhibit 1, question 25.
Okay,
you refer to which parts of 551D8 that you're testifying to in this case, and which parts Mr. Villalobos is testifying. But then at line 18, you list 18 and 19, you list a whole bunch of subsections that you say that were provided and resolved in 25.00038. So is it your understanding that the commission would take an approval under 572 and transmute it in a different docket, different parties, and use it to make a finding in this case under a different statute.
Does our hearing examiner object to the question as compounding and vague?
I'm going to sustain the objection. And Ms. Stevens, I see where you were going. I think it just requires a clear statement of your question.
May put it differently. Why did you not choose in this docket, Mr. Novella, to address each of the 551.8D factors or requirements, if you were in fact from the beginning asking for the alternative possibility of it alternatively approving this procurement under that rule?
So first off, we're seeking here in this case for approval under 572. Now, here, as you're pointing out, 551, with regards to Rule 551, I wanted to be helpful and point out to the parties where exactly we're complying with regards to not just 572, but 551. Now, in 551, there's a lot of necessary information that's already been supplied by EPE in the previous RPS case, which is the case that we got the approval for Santa Teresa's 150 megawatts of battery. I'm sorry, 150 megawatts of solar and 50 megawatts of battery. The PPA and the associated ESA was already part of that case, evaluated. And so uploading it here in this docket wouldn't be proper. That's already been resolved in the 25-00038 filing. So there's no need to do that again here.
And that's your legal opinion. Is that not what's been resolved and what hasn't been resolved?
That is
I
my
object. That's argumentative.
No, it's
I'm going to sustain the objection. Ms. Stevens, restate your question, please.
okay. It wasn't meant to be argumentative, but that is your opinion about what's necessary to present in a docket and what isn't necessary to present in a docket.
It goes beyond me. And obviously, when you work in a case like this, you're getting input from your legal counsel, both internal and external, as you develop your case. So this was founded upon more than just my viewpoint.
Okay, I think I have just one more question for you. And I have a similar question for you about your interpretation, where you start referring to matters of law, and it has to do with the Supreme Court opinion discussed in your rebuttal testimony. You do agree that it's up to the commission and ultimately the court to make legal decisions, right?
Legal decisions, yes. My interpretation here was clear. This was a non-precedential order that was done before the revision or amendments to the overall statute that allowed for the changes that we're seeking here. So that's just my interpretation that order didn't really relate to what we're seeking here.
Okay. Finally, I'm going to ask you, I know that this won't necessarily go over well, but since you are a company witness, are you familiar with President Trump's Ratepayer Protection Pledge from March of this year?
Generally speaking, I haven't read it, but seen news headlines.
And do you know whether any of the parties involved in the development of the large load project in southern New Mexico.
I'm going to pause this. I'm sorry. There's feedback. Does somebody have their YouTube on? All right.
You know what it probably was? I put paper on top of my speaker. Could that have been the
It
problem?
sounds better now, so I think you've
Yeah,
diagnosed
I'm
the
sorry.
problem.
Haven't gotten used
No
to this
problem.
computer yet.
No problem. I'm
I
sorry for
apologize.
interrupting. Please proceed.
Okay, so you are somewhat familiar with it. Do you know whether any of the parties to the development of a data center in Doñana County were signatories to that pledge?
I don't know.
And would that pledge, to the extent you know anything about it, something about it, is the idea that the incremental cost will be incurred by the data center owners rather than ratepayers?
And I'm just sorry, I'm confused here. Are you asking about the earlier at the beginning when we started, you're asking me about the large load customer that we're talking about with EPE, but then you were asking me about the other data center you were asking me about Jupiter, and it sounds like you're talking about Jupiter and not the one that we're looking at serving. So I'm just confused. Who are you talking about?
I'm trying to talk about I learned from you that the Jupiter is different. No, I'm talking about the development that you're working with, the Borderplex, and whether you know whether any of the intended participants in that or actual participants in that have agreed to this repair protection pledge.
I don't know.
Okay. And do you think that that would be relevant or important to the company in figuring out how it's going to proceed with serving its legacy customers, for lack of a better term, and these that's somebody else's feedback. Hugely large, new customers?
I'm not familiar with that document, so I can't say, but I will say this, we're very committed to protecting our customers through tariffs, energy service agreements, and having the language necessary to make sure that none of these customers are subsidized from our existing customers. And we've been very vocal about that. And it's something that I take full responsibility with the rates department in the purview of my responsibility that we do that.
Well, with that, Mr. Novella, I'm going to sign off and thank you very much for putting up with this.
Thank you, Council.
Okay. Thank you, Ms. Stevens. I see that Council for Doñana County has been able to join us. I hope you weren't waiting in the waiting room too long. And do you have any cross-examination for EPE witness Novella?
No questions at this time. Thank you, Mr. Examiner.
Okay, thank you. Okay, that is the extent of cross-examination by the parties. I have some questions, Mr. Novella, that I've developed. And so I'm going to get organized on those here for a second and ask a few questions that I have. So if we go to your direct testimony and we go to page 10 of your direct testimony. And I'm on lines 8 through 14. I'll let you refresh yourself there.
Okay.
So can you explain to me what you mean by relying on the flexibility in the context of being limited once the PUCT approves a system resource? How does the flexibility that you refer to there integrate with your recognition of that limitation by the PUCT?
Sure. So in Texas, many times, and this can go for either jurisdiction, once the asset or facility hits COD, doesn't mean that it's been automatically approved by the jurisdiction. So what we've been doing in Texas with regards to some of our facilities that were built for our Texas customers is use them on a temporary basis to meet RPS goals before they're approved. And in Texas, you essentially can approve these resources in general rate cases, but also in fuel reconciliation cases if there are PPAs there. So what'll happen is, say, last year is a good example, sir. We had a Milagro facility. It's a Texas facility, started, and we use that for reassignment to New Mexico. And it still has not been approved in Texas. We have a fuel reconciliation case coming up this year, and we'll seek that approval in Texas. So I believe my regulatory opinion is that we have the freedom to reassign these on a temporary basis to help reach our New Mexico goals. Once it becomes a Texas asset, though, then we have to go into Texas and seek approval. And sometimes that doesn't work out timing-wise. What if it's rejected? You never know, with regulatory matters. So that's what I'm alluding to here.
So, and Ms. Stevens, I don't know if the feedback was from your microphone, but it's still on. If you're able to mute yourself, I can do it for you.
I will, but I don't think it's.
There, I just took care of it. Thank you. So in that situation, Mr. Novella, where it gets temporarily used for New Mexico, but then it gets approved in Texas, what's the process for then removing it from being used for New Mexico, both being used for New Mexico and being charged to New Mexico's ratepayers?
Generally speaking, our energy accounting team does it in a way where we get a pre-approval or authority to do that temporary reassignment for a given period to reach a certain goal, usually an energy basis. So we'll get a pre-approval in the New Mexico side that we'll need X amount of kilowatt hours, and we'll estimate how long it'll take us, how many months it would take us to get those amount of kilowatt hours. So it's always capped by that. I've never seen it stretch beyond, say like that year, because we're always kind of generally speaking in like an annual term that we'll need that reassignment for that given year.
Okay. And so have considerations of that flexibility gone into EPE's treatment of the Santa Teresa additional 100 megawatts of BESS? Was there a consideration of a temporary? Sorry, I just got some really bad feedback. I don't know where it came from. Let me get this question clear after that. Are other people getting feedback as well?
I heard that as well.
Okay. And Ms. Gonzalez, are you hearing things okay?
Yeah.
Okay. If you've rearranged it all, it may be that we're getting a little feedback from you. Right now, it sounds great. But you're the only other microphone I see on in addition to the witness. I think it's just fine now. I don't know what occurred. So I just wanted to ask you that question and make sure you were hearing well. Okay. Sorry, Mr. Novella. I'm back to you now. Before applying for the additional 100 megawatts of BESS in this case, in 26000093, did you explore options for temporary use of the BESS in New Mexico in order to manage your jurisdictional allocation of this resource?
I don't believe so. At least not any conversations that I took part in.
Okay. Uh, And if this resource isn't approved, if the 100 megawatt of BESS assignment isn't approved by the New Mexico Commission for assignment fully to New Mexico, does the company have an opportunity to apply for this 100 megawatts of BESS to be assigned to Texas?
So I don't believe we've explored, and maybe they have on the resource planning side, alternatives and, but I would imagine so. I wouldn't see anything that would preclude us from seeking it in Texas. I wouldn't, or an alternative, as I mentioned, the large loads, customers want any kind of capacity that they can get. I could imagine there's probably several folks that want this kind of resource, especially at the price that it's at. From what I understand, it's a good price. It's here and now, which is rare nowadays. Everything's years out. So having a here and now capacity resource like that, I could see there being interest.
Okay. And you haven't applied for approval elsewhere for this 100 megawatts of BESS, have you?
No.
And there's testimony, I don't remember if it's yours or it's Mr. Villalobos, that the projected go live date for the battery portion of the Santa Teresa project was end of June 2026, if I recall correctly. Is that correct by your recollection as well?
Yes.
So if the project goes live and you don't have a final order with approval for this BESS, in this case, until September, for example, and you don't have approval for it elsewhere and it starts to be used, how does EP recover the costs for the usage of this BESS, this 100 megawatts?
Yeah, I'd have to give that one some thought. And I think, first off, to your question, I think we always understand there's some kind of lag there, regulatory lag. So it's just part of the business. And I think we understand we'd have to wait a couple of months for that kind of this proceeding to end. With regards to your question on cost recovery on the asset, if we don't have approval, I would see it as we'd be unable to recover it from our New Mexico customers in the manner we're requesting. I'd have to honestly give it some more thought on what are alternatives versus not being able to recover at all. I think we'd have to sit down and be a very thoughtful conversation on what are our options that I don't have ready for you.
Okay. So generally, is it correct to understand that EP has been conscious that in their prognostications for 2030, 2035, there's an expectation for demand growth that has not become a conscious understanding just in consideration of this docket, but that existed as early as January 1st, 2025, for example, that load growth was going to ramp up over time?
I think just generally speaking, the last 2 years or so, yeah, we've seen a takeoff. Now, personally and anecdotally, I think that's gotten steeper and steeper, and people want more and more. So although from 25 we saw a big need from just our local folks, just locally, like I mentioned, that peak that we hit recently, we've seen such a tremendous growth. And then we saw large load growth last year that, we started taking them into our account to our forecast. It's just accelerating with regards to the amount of folks that want power and the amounts. So I would agree that it's been in our line of sights for a bit, maybe 2 years at least. But what's not there was the magnitudes, which are pretty immense.
So, so then my question is, and you referenced the load growth that you're having with your organic customers, and that this additional 100 megawatts of BESS you would like to have to serve those customers. I believe you, and I'm paraphrasing, correct me if I'm wrong here, that regardless of that large load growth, you thought this battery was useful for the load growth for your organic customers. Given that and the general awareness that's existed of that growth and the timing of this case with respect to when that battery resource is expected to go into service, which is essentially now, why did you not apply for the additional 100 megawatts of BESS previously as a company?
Yeah, it's a good question, Mr. Hearing Examiner. I'm not sure exactly the analysis from the resource planning that led to just getting the 50 megawatts. That might be a better question for Mr. Villalobos of why they didn't come in for the full 150 megawatt battery at the time, which would have been last year.
I'm going to make a note just a second. Have you been part of other dockets with the PUCT where you've applied for battery resources that have been denied by Texas?
I don't think that have been denied. So I'm generally in all the Texas CCNs, and let me think about it real quick because it feels lately like there's, and I'm sure you can appreciate there's so many filings.
I'm sorry, I'm sure you can appreciate.
There's been so many filings. Just no, I don't believe, and to answer your question, that nothing has been denied with regards to a battery resource that I can think of in Texas. We've been getting approvals. One was we have a site called Felina, a solar battery. We got a CCN approved there, and we're in different statuses in other cases for other facilities that are similar in that they're solar and paired with battery, and it's just obviously a very different regulatory process with different kinds of filings, even in between the CCN and the rate case. But yeah, I don't believe there's been anything disapproved.
Okay. Are you aware of disapprovals of other battery resources from other utilities in your awareness? I mean, and I ask this question because your testimony speaks to, your participation across both states and jurisdictional allocation. And so I'll ask it just very directly. Would one piece of EP's interest in getting approval for this 100 megawatts now in New Mexico be because there is a possibility EPE sees that it won't get approved in Texas?
No, and the reason I say that, the Felina battery, or Felina site, it's kind of like this one in that it's solar and battery, 150 megawatt solar. I don't recall the battery size, but we got the CCN for the battery approved in Texas, and I've gone through pretty much all of the litigation portion of another facility called Newman Buffer that's also solar and battery, and we're in the settlement phase that I can't get into, but seeing the back and forth there, I don't see that battery being a real issue. So no, not avoiding Texas having batteries.
Okay, thank you for that. So This question was generated in review of page 11 of your direct testimony. And it's on lines 5 through 8. And you testify there. Sorry, there's a little bit of feedback from our court reporter. I'm sorry, Miss Gonzalez. I'm not sure where it's
Okay.
coming from. All right, thank you.
Either
Sorry.
the air conditioning kicks on, but we really need it here. I hope
Oh
it's
no,
not.
please, it kicks the voice back. It was doing it. It didn't do it at all this morning. It just did. That's the second time
Weird.
it's done
Okay.
it now. Your microphone picked up my voice and fed it
You,
back to me.
you can cut me, I can cut me off and raise my hand and do this if somebody's looking at me, if I need to clarify something. How's that?
That sounds good. I hate interrupting your work in any way. All right. Mr. Novele, were you able to get to page 11 of your direct testimony?
Yes.
And so you testify there to that you delivered well over 40% of of the retail energy sales to New Mexico customers with renewable resources in 2025. Is it correct that EP was deficient on REC retirements, I believe in the years like 2021, 2022, and perhaps another year? Are you aware of prior deficiencies that EPE had?
Yes, I am.
Is EPE still considering making up for deficiencies? And I asked that question with a specific reference to my recollection of last year's case and perhaps the year before of a possibility that EPE was interested in exceeding the 40% level retirement of RECs in order to make up for prior deficiencies. But I didn't see anything in this case. Is this still a consideration for EPE, or is it no longer a topic?
I believe it's still a consideration, and I was a part of several of those RPSs. Are my first ones. At least I can't recall the year. They all blend together, but I recall discussions with our own team, and right now we're barely above. You see there over the RCT, 40. I think we're about 44%. So I think it's something that we want to talk about more with time to see what that amount looks like that we're banking. And do we or do we not? What does the commission want us to do? What do we do with regards to those previous deficient years where there was a lot of back and forth? If we were I think we were calling it backfill back then. We're going to backfill the RECs. So yes, we've had internal conversations, but right now we barely kind of have enough to start that discussion. Nothing meaningful yet in terms of overage of RECs.
So the excess that you had in 2025, those are banked then, is that correct? Of what you exceeded in 2025 beyond 40%? Did you bank those RECs for future usage?
I would describe them as that as banked. Yes. Mr. Villalobos may be better at like the definitional because his team handles the retirement of the RECs. But I would say that would be fair. It's that right now there's some that are banked or forgive, and my understanding is they expire after a certain amount of length of time. So we want to do something with them. But right now it's just the overage is so little. I don't know how much meaningfully we can make a dent into those backfills, but it is a discussion at EP that we've had.
Okay, thank you. My next questions you already answered, I believe. I'm going to triple check. Okay. Nice. Okay, I want to turn to page 22 of your direct now. And my note, I wrote down line 7. And the reason I noted that is you testify there to EP's strategies for rate design. In this case, EP has proposed to move the energy costs for its PPAs from the RPS rider to the FPP CAC. Is that correct?
That's right.
So is it correct that the FPP CAC is done on a straight per kilowatt hour basis as far as allocation to ratepayers?
Mr. Henry, I'm not as familiar with the FPPCC, so I don't want to misspeak. I've never actually testified in one of those cases, just on the fuel side for Texas. So I wouldn't be a good person to ask for that. May it be Mr. Gonzalez, our third witness, who's handling the rider. I think he could field those questions better for you.
Okay. And
however, with regards to the policy side or why we're doing what we're doing, I'd be happy to answer anything you have, sir.
thank you. I'm referencing something farther up. Just one second. Okay. So you state on page 2 that you oversee and direct the activities of EPE's rate research department. Is Mr. Gonzalez in that department?
Yes.
Okay. 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 I'll save my questions for Mr. Gonzalez then with regard. But I'm going to ask you the question and you can redirect if needed. In this case, we see impacts to the RPS rider. There's tables provided as to the reduction in the RPS rider rate that's applied to ratepayers. Did you provide testimony as to what the increase in the fuel clause rates would be to ratepayers?
I can't recall if Mr. Gonzalez did. I know we're essentially moving one bucket of cost into another bucket, and that's why we have a decrease here in the RPS rider. But I'm not sure how he presented them. I thought seeing tables where he did kind of show those dollars moving into the FPPCAC. Now, I'm just not sure on the presentation.
Okay. And my last question then is probably for Mr. Gonzalez, but I'm going to ask it anyways, do you know whether the allocation of that bucket of money to different rate classes is identical when it's charged to ratepayers through the RPS versus when it's charged to ratepayers through the FPPCAC?
I don't.
You don't. Would Mr. Gonzalez be able to answer that question?
I believe so. If not, we can make sure that he gets that by the time he goes out. And my only reservation, it's just that sometimes in fuel, they can adjust allocators for dedicated resources and things like that. So I just got to make sure that, what they do, that those allocators just, you asked the question, are the same. I'm just not familiar.
Okay. Okay, then I want to turn to page 23 of your draft testimony, please.
Okay, I'm there.
And let me catch myself up for a second. Okay. this morning there was a discussion about this, and I believe it's in your direct testimony as well, that the final order in 25-00038-UT ordered EPE to address the recovery of the Santa Teresa project in its next rate case. Is that what you recall as well?
Yes, it is.
And you have a rate case going on right now, correct?
Correct.
And what I see here on page 5 through 9, you state that EP previewed its proposal to move energy costs related to the STP PPA to EPE's FPPCAC, but recommended the commission wait to address that proposal with an order in this filing. Given that final order in 25-00038 and your direct testimony here, why are you applying for this shift to the FPPCAC here as opposed to in the rate case that's currently ongoing?
Yeah, when we thought about this, and you kind of think of what's the easiest streamlined approach for everybody, for all parties, it felt like it would be cleaner from an administrative point of view, and that we get the energy addressed here with regards to fuel reconciliation filing, and we get the energy costs done on the general rate case side. So it's just as we talk through it and administratively walk through the path of seeking them both in a base rate case or seeking them the energy here and the base rates or capacity costs in a general rate case, this just seemed the cleanest to present to all parties that everything was accounted for properly. No double counting and issues like that. It just felt like the cleanest from a presentation point of view.
Okay. Okay, then my next question is this. If the 100 megawatts of BESS is approved in this case, and it's direct assigned to New Mexico, 100%, that provides a capacity benefit that will be charged to New Mexico, correct?
That's right. They'll pay for the capacity costs associated with that resource.
And that means that Texas ratepayers would not pay for that capacity, correct?
That's right. And in return, New Mexico would have a smaller allocator. So what we would do mathematically is, and it's part of my team and the load research side, what they do is they'll get both states and reduce each state's dedicated facilities. So New Mexico, because they paid for all of it, as you stated, they'll get 100% of that reduction on their allocators for that capacity. So make sure they get 100% of the credit. So any usage for other system resources, you'd see essentially Texas's allocator go up because now they're going to be using a greater share of our existing resources, and New Mexicans now will rely less on those and more on this resource.
When would that adjustment to the jurisdictional allocation occur?
Generally speaking, we do them during rate cases. Now, there may be something done on the fuel side that's more routinely done. I'm just not familiar right now with what they do on the fuel side for the allocators for dedicated resource with regards to the speed. But on the allocators that we do for cost of service, those would be done in base rate case proceedings.
Okay, so if the 100 megawatt BESS from STP is approved in this case, it would go into rates on January 1st, 2027. Is that correct?
Yes.
And when do you expect a final order in your rate case?
I would expect it sometime this fall, late fall.
Sometime this fall?
Yeah, late fall. Or I'm sorry, recommended decision. Q1 of 2027, a final order.
Okay. And do you know whether an adjustment to the jurisdictional allocation has been proposed in that rate case to account for an assignment of the 100 megawatts of BESS dedicated to New Mexico?
It has not. It's the portion that has currently been approved for the 50 megawatts of BESS. So that would be a future rate case proceeding, or maybe something that gets worked out in settlement or discussions in that rate case. Obviously, I can't speak to that. That's very early to say, but I could see that being something that parties talk about.
So hypothetically, if there wasn't an adjustment to the jurisdictional allocation of capacity accomplished by January 1st, 2027, and the 100% assignment of the STP, 100 megawatts of BESS, went into rates, New Mexico's ratepayers would be paying for the 100% of the STP BESS, and they'd also be paying for a jurisdictional allocation that was not adjusted to account for that 100 megawatts of BESS that's assigned to Mexico 100%, correct?
That's right. So every time a jurisdiction approves a resource, you don't change the allocators immediately. So the same thing would happen vice versa. Texas approves a resource, their allocator doesn't go down immediately. And so you're always updating after the fact. There's always some kind of lag.
And if EP were to file another rate case, that lag, even if EP filed a rate case within 1 month after a Q1 2027 final order in the current rate case, we couldn't expect another rate case to be completed for at least 1 year, correct?
I would agree. I think we'll be coming back in sooner than what was the history of like a 4 or 5 year cadence. But again, I could see this being a discussion point in our current rate case. So it wouldn't surprise me if, this is a discussion with other parties. I haven't had any of those discussions. Obviously, that's a currently open case that we're litigating, but that's something that can be talked about there. So that could speed up with what you're describing if parties were to agree to something. If, for example, this case gets approved and now there's certainty around the facility being 100% dedicated, I'm sure EP would be open to working on those allocator assumptions and changes.
That would require supplemental testimony in the rate case, right?
I would imagine so, but with regards to settlements and discussions like that, I could, I'm not sure, right? It's kind of, as you well know, the regulatory process. I could see that being in a settlement. I could see that maybe that's probably most likely where it would take place. But again, it's just kind of an item that if we see approval here and parties bring that notion up to update our allocators for this now known and measurable change that is 100% dedicated, I think that's a fair topic to start talking about.
Okay, thank you. Here's what I'd like to do. I'm not sure, I think I've gotten to the end of your questions, but I'm a little bit disorganized at my desk right now. It's 2:24. It's not a bad time for an afternoon break. If we can take a 15-minute break, that'll allow me to review my notes. It'll allow me to rename those 2 documents that need to be renamed and uploaded to Dropbox. We can all take a nice little afternoon break. My office can cool off a little bit, and we can reconvene here at 2:40. Any objections to me taking that break right now? Mr. Herman.
I was just going to request permission to remove my jacket for the remainder of the proceedings today.
Permission granted. I won't allow myself the same, but when my door is closed, this office gets warm. Okay. Thank you, everybody. And the YouTube will still be on, and we'll reconvene at 2:40 p.m. Thank you. Okay. I apologize for being a minute late. Zoom decided to put itself in a really weird location on one of my screens. I couldn't find it. I panicked. Okay, there's Mr. Herman. Okay, it appears we have representatives. Okay, we're on the record. The first thing I'm going to cover here is that over the break, I uploaded to Dropbox an exhibit labeled CLC exhibit number 1 underscore docket number 25-00038 UT underscore application underscore corrected exhibit number 1. That was the document we discussed this morning that is provided by City of Las Cruces this weekend. I also uploaded CLC exhibit number 13 underscore docket number 22-00093 UT underscore amended application underscore corrected exhibit number 1. The one piece to note on that corrected exhibit number 1 for CLC exhibit number 13 is that in its title it says amended application. The original exhibit number 13 just said application, but I think it's clear what was accomplished there. Are there any questions on that at this time? Okay, if y'all download that at some point and it does lead to questions, please just raise it with me. Thank you. Okay, I reviewed my notes. I have just a couple more questions for you, Mr. Novella.
Yes, Mr. Hearing Summer, if I can, one point of clarification.
Yes.
When I went on the break, you had asked me the question if any solar or battery has been denied in Texas, and the answer is still no. But there's so many filings, I was just kind of mixing some up. The Felina CCN approval right now is just for the solar, although we're moving along pretty quickly with the battery. And we've grouped that with other projects I didn't list, but they're called Copperhead and Black Mountain. They also have battery. And there's also the Newman buffer project I mentioned that's also moving along.
I'm sorry, there's also the
Newman buffer, but I made it sound like the Felina battery CCN had been approved, but it hasn't yet. It's still going through the process. So I just wanted to clarify that, sir. Thank you.
Thank you. I appreciate it. Returning to the, what's been requested in this case of moving the energy costs of EPEs, PPAs into the FPP CAC. Could that be accomplished in a rate case by your understanding?
I'm not sure. My inclination is to say yes, but I think when we had these conversations with our energy accounting experts and our legal staff, I think the response was we could, but it would be more proper to do it in this avenue and again make it more clearly separate for the purposes of proving that there was no double counting and that the counting would be clear, is my recollection from that conversation.
Okay. Similar but different question is in your rate case filing, have parties been put on notice through your testimony or EPE testimony of an expectation that the costs for energy for PPAs would be going through the FPP CAC?
Yes.
If it's approved in this case?
Yes, sir. I noted it, I believe, similarly how I did here, where I mentioned the other proceeding and that we're seeking a similar kind of treatment, but in reverse.
Because thank you for that. Before we went on break, and I went back and looked at the transcript a little bit, and it's a little bit fuzzy at this point. But I believe you mentioned that in the fuel clause, there can be adjustment to the allocated resources based upon agreements with, was that with particular customers or particular rate classes? Can you clarify those statements if you recall what I'm referring to?
I'm glad you raised that because I didn't mean that to sound that manner. I believe what we were talking about, and please correct me, it might be a different issue, but I thought we were talking about allocators for cost of service, and you were talking about how those allocators get updated in rate cases. And what I was referencing was that those are in discussions and currently being litigated for a current rate case. So parties can take the stance if they chose to that we should adjust those allocators to give New Mexico 100% credit of the 150 megawatts of BESS if they were to put that stance out there. So if this were to get approved, I could see people wanting that because now it's a known and measurable change, argument it could be made. And that then we would have to reflect a reduction for the dedicated facility to New Mexico. That's what I was referencing.
Okay, that helps to clarify. Okay, that's enough on that. Are you familiar with the testimony in this case? And I'm sorry I couldn't locate whether it's yours or Mr. Villalobos. That the levelized cost of energy that's presented for the STP includes network upgrade transmission costs in the costs of the PPA.
I recall the back and forth, but that's best for Mr. Villalobos.
Mr. Villalobos. Okay.
Yeah, that's right.
Okay, and then here, it's one piece I couldn't find over the break. Correct me if I'm wrong. What I recall reading, and it was with respect to I believe the acronym is CAGR, which is prognostications for load growth estimated on a yearly basis over a long-term period. There's been a hand raised by Miss Amer. Yes, Miss Amer?
I apologize, but they said that my video was disabled by the host.
Really?
Thank you.
Great. I apologize if we did something inadvertently. I apologize. All right. Thank you. Great use of the hand. Okay. Getting back to the question. And I'll raise it with Mr. Villalobos if I need to get my details more correct between now and then. But what I recall seeing is that, there's an estimated load growth as presented through the CAGR of somewhere in the range of 2 to 3.5% yearly up until 2035. But I also recall seeing that in 2027, there's a reduction in yearly demand. Is that correct? Do you have knowledge as to that?
So a bit. So the CGR is our compound annual growth rate, and you described it properly, just kind of a different way to view growth. They call it like a geometric versus arithmetic growth rate, but the percentages.
Sorry, geometric versus a what?
Arithmetic. And so I apologize because I don't even think we, in this case, spelled it out, the CGR. But I recall the growth that we're seeing, and you're seeing these large increases in near-term growth, but I do not recall a dip from one year to the next. That sounds surprising to me, unless we're looking at maybe different forecasts somehow, kind of compared. But like if it's one individual forecast, the way at least I would see it is it's all stacking up on top of one another, and there shouldn't be a dip.
Okay. I appreciate that, and I'll do a little bit more research, and I'll try to ask the question just a little bit differently then. If in 2027, well, first, is the additional 100 megawatts of BESS necessary to meet what EPE has diagnosed as being necessary for capacity for New Mexico in its current IRP in 2027?
My understanding, it is from reading over Mr. Villalobos' testimony and understanding his analysis, but he could probably expand on that a bit more than I can. It's just learning from him and his work that I understand that it is needed for that.
Okay. Okay, then I have no more questions at the moment. I appreciate you answering my questions, and I'll do a little work to prepare for Mr. Villalobos. And with that, I apologize. Miss Olson, do you have redirect? And I should have asked you for this immediately after questioning was completed by Miss Stevens, but I now give you the floor for redirect, both based on Miss Stevens' questions and my own.
Thank you, Mr. Hearing Examiner. I don't have any redirect.
Okay. Okay, with that, I want to say thank you to Mr. Novella, and thank you for your testimony today. Yes, Miss Stevens, you have a question? Do you have redirect based upon my questions? Oh, you're on mute. I'm sorry. I'm sorry. You're on mute. Let me unmute you. I'm trying.
Oh, I
There
gave
we
me the
go.
option to unmute myself. I guess you gave me the option to unmute myself. I will lower my hand. And this is going to be very quick because I think Mr. Novella sort of told me earlier that he didn't know too much. But Mr. Novella, when you mentioned rather early in Mr. Getko's examination that there was a lot of enthusiasm for the unused 100 megawatts of the Santa Teresa BESS. Could you explain whether or not, first of all, I think I can with 150 megawatts allocated to New Mexico of output, do you agree that any use of that battery by another party, including even the Texas jurisdiction, the energy would have to come from somewhere else?
So a couple things. It's just, to be honest, if I could get that question again, but maybe rephrased. But you started with that there was a lot of excitement for the 100 megawatts of this BESS, and hopefully I didn't make it sound like exactly there's excitement for this specific facility. I don't think people understand this facility is there. What I meant more is that there are a lot of people that want capacity from any kind of resource, BESS, solar, anything that's here and now. And this facility is here and now. So that's just what I meant, not that there's excitement for this specific facility. I don't think people even are aware of that. And to your question, if you can rephrase it or restate it, I'm sorry, just.
Okay. So if the commission were to deny the and this, if it's too technical, it goes to Mr. Villalobos. I know if the commission were to deny this request, would EPE be in a position to sell that capacity either on a long-term or a short-term basis to somebody other than, other than dedicating it to the New Mexico jurisdiction, given that the solar is connected to it?
Again, I think I answered this to Mr. Getko. I don't believe we've evaluated exactly what we would do if it were to be rejected, whether sell it to a private party. I don't know exactly what our options are moving it towards Texas approval. So maybe Mr. Villalobos has given that more thought, but I haven't done that.
And right now it's operating, but is it only being charged up to
Ms.
the
Stevens,
50?
that's, I did not ask questions about
Okay.
whether it was operating now.
Okay,
This
okay,
is
I'm sorry.
redirect.
I
Do you
think
have
that's
any
it.
other questions that are based
I
upon
think
the
that's
questions
it. Thank
I
you. I
asked?
will follow up with Mr. Villalobos.
Okay. With that, I want to thank you for your participation today, Mr. Novella. And
Thank you, sir.
you can be excused, and I hope you have a good afternoon.
You as well, sir. Thank you.
Um, okay. Okay, I'm not perfect as I go through this, and I don't want to have to return, but I should have at least vocalized. Does anybody else have redirect? I realize that looking at the transcript, that I asked just Ms. Stevens. Does Doña Ana County have any redirect?
No, thank you, Mr. Examiner.
And staff, does staff have any redirect for Mr. Novella?
No, thank you, Mr. Hearing Examiner.
Okay, thank you, everybody. With that, it's time to turn to our next witness. So I'll turn to Ms. Olson for the introduction of EP's next witness.
Thank you. EP would like to call its next witness, Mr. Emmanuel Villalobos. And I think they're just swapping out in the witness room, so the camera should come back on in just a second. Good afternoon, Mr. Villalobos.
Good afternoon. How's everybody doing?
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Villalobos, could you please state and spell your name for the record?
My name is Emmanuel Villalobos. That's Emmanuel. Villalobos is V as in Victor, Illalalo, B as in boy, OS.
Mr. Villalobos, what is your current position with EPE?
I'm the Director of Resource Strategy.
Do you have before you what's previously been marked as EPE exhibit number 3?
Yes, I do.
And do you recognize that as your pre-filed direct testimony prepared in this case?
Yes, ma'am, it is.
And was that pre-filed testimony prepared by you or under your direct supervision?
It was.
Is the information contained therein true and accurate to the best of your knowledge and belief?
Yes.
Do you have any corrections to your direct testimony?
No.
If you were asked the same questions today under oath, would your answers be the same?
Yes.
Mr. Hearing Examiner, EP would move for admission of EP exhibit number 3, direct testimony of Emmanuel Villalobos.
Thank you. Are there any objections to the admission of EPE exhibit number 3?
Yes, Mr. Hearing Examiner, I'm not sure whether this is a voir dire or an objection, but I thought that Mr. Villalobos's testimony changing the little table of the allocations of various resources that add up to the amount, the annual recs, was intended to change his direct testimony. And I guess I would either ask Ms. Olson to clarify that, or to allow me to voir dire him. I don't want to do that. I just was totally expecting that there would be some changes made.
Ms. Olson?
Yeah, I think what Ms. Stevens is talking about is a change to the position that was presented in rebuttal testimony. And I think that those changes are explained in the rebuttal testimony. And so my suggestion would be, if Ms. Stevens has questions about those changes, that sounds like a topic for cross-examination, not examination of the direct testimony. I think it's always confusing when you present direct testimony and then someone raises a question about that and you respond to that question in rebuttal, whether that's truly a correction to direct or whether that's a kind of revision to the position or presentation on rebuttal. I think it might just be cleaner and easier to understand if we don't treat it as a correction to direct testimony, but we let the rebuttal testimony kind of stand on its statements for cross-examination.
Thank you, Ms. Olson. I want to give parties the opportunity to respond to that. Anybody?
Including myself?
Yes?
I think this is a fairly clear-cut case, and I don't, that he did, the particular table I'm concerned about is actually labeled as corrected exhibit, is table EV1. And I think in terms of clarity, it would be much more efficient and clear to have him point out himself what he's not, what he's replacing or what he is maybe perhaps instead supplementing, rather than to ask me to go through doing that, because otherwise his testimony is going to be in some way, when we get the record, it's going to be somewhat contradictory.
Well,
I guess I'm
my
saying
understanding-
the company has the better knowledge of what's.
So my understanding is that the corrected exhibit exists within and is attached to the rebuttal testimony of Mr. Villalobos. Is that correct, Ms. Olson?
Yeah, I think if you look at Q11 in the rebuttal testimony, it answers that question. Have you corrected table EV1? Yes, below is a corrected version. So I think exactly what Ms. Stevens is asking for is spelled out in his rebuttal testimony.
Okay, so the way we're going to proceed is we're going to admit the direct testimony as it is. We're going to admit well, barring other objections, we'll proceed to direct testimony to attempt to admit the rebuttal testimony of Mr. Villalobos, and we'll proceed with an understanding that the rebuttal testimony provides an explanation of the corrected exhibit, and the direct testimony will provide the exhibit that was incorrect and therefore corrected. So on that basis, I would deny the objection to the admittal of Mr. Novela's direct testimony. Are there any other objections?
No.
Okay, then EPE exhibit number 3 is admitted to the record.
Mr. Villalobos, do you also have what's been previously marked as EP exhibit number 4?
Yes, I do.
And do you recognize that as your pre-filed rebuttal testimony?
Yes, it is.
And Mr. Villalobos, was that rebuttal testimony also drafted by you or under your direct supervision?
Yes, it was.
And are the statements in your rebuttal testimony true and accurate to the best of your knowledge?
Yes, they are.
And if you were asked those same statements or same questions today under oath, would your responses be the same?
Yes, they would.
Mr. Hearing Examiner EP would also move for admission of EP exhibit number 4.
Are there any objections to the admission of EPE exhibit number 4?
Yes, sir.
What is your objection?
I would actually like to voir dire the witness in terms of this one. It has to do with question 21 in his rebuttal testimony and some of his exhibits. Mr. Lee, I'm being rude. He,
May I respond?
Yes, please respond, Ms. Olson.
Ms. Stevens has not raised any objections to this testimony under the procedural schedule, like moving to strike or objecting to the expertise to give this testimony, which is what I would expect voir dire to cover. And I would object to Ms. Stevens doing cross-examination on this question in a voir dire capacity. I think if she has questions about it, she can cross-examine the witness on his testimony.
Ms. Stevens, for clarity of the record, can you explain the request for voir dire as opposed to cross-examination?
The request for voir dire, well, the deadline for filing motions to strike was, I think, 3 days after rebuttal testimony. And so of course I couldn't turn around and do discovery to the company. So really what I want to ask, this is, has EPE evaluated more recent market data to confirm whether the pricing secured for the STP continues to be advantageous for customers? That's the question. The question really is, was Mr. Villalobos or the company able to provide this same analysis in its direct testimony? Because otherwise, I believe the company is supplementing its direct and not providing rebuttal testimony, true rebuttal testimony. It's just trying to enhance, insufficient showing that could have been in its direct case, if the timing is such that it was possible to do that. So that would be the purpose of the voir dire.
May I respond?
Yeah, I'll allow one more response and then I'm going to consult with my co-hearing examiner and make a decision. Yes.
I would just respond on 2 points. One, as stated, this is directly responsive to additional information staff asked EPE to respond to and rebuttal. And so I have a hard time following Ms. Stevens' logic that this isn't rebuttal testimony. And 2, the timing of when EPE became aware of this information does not go to Mr. Villalobos's knowledge or experience to be able to provide this testimony, and therefore I don't think it's appropriate for voir dire. That sounds like cross-examination.
Okay, thank you, counsels. I'm going to deny the objection and admit EPE exhibit number 4, barring objections from other parties. Do any other parties have objections to admitting EPE exhibit number 4 into the record? No? Hearing none, EPE exhibit number 4 is admitted.
Thank you, Mr. Hearing Examiner. EPE has no other exhibits to introduce with this witness, and so we pass him for cross-examination and examination by the hearing examiners.
Thank you. Staff, do you have cross-examination for this witness?
Mr. Hearing Examiner, staff has no questions for Mr. Villalobos. Thank you.
Okay. City of Las Cruces, do you have cross-examination for this witness?
The City of Las Cruces does have cross-examination, Mr. Villalobos.
Okay, and just to update you a little bit, by our time calculations, you've used 2 hours and 30 minutes of the 4 hours and 30 minutes allotted for cross-examination. And I'll remind that slight statement I made at the start of the afternoon of there may be a tiny little bit of flex at the end of that, but that gives you a general idea that you have 2 hours remaining.
Okay, I'll talk fast.
No, please talk clearly.
I always do.
Thank you.
Good afternoon, Mr. Villalobos. I got a smile out of you there. That's a good start. I was going to say I don't have as many questions for you as I did for Mr. Novella, but of course he deferred some to you. So I'm going to try starting with some of the deferred questions, okay?
Yes, absolutely. Thank you.
And they're not going to be necessarily dead on, but the topics are. Um, so I would like you to please refer to CLC exhibit number 26.
Maybe just give me a moment to bring that up. Okay.
Okay, and in your role, are you familiar with this RFP that arose out of the New Mexico Integrated Resource Plan process?
Yes, ma'am.
Okay. Is that RFP still open for bidders?
The RFP is still ongoing, yes.
Yes. And is El Paso Electric Company eligible? Oh, I'm so sorry. I thought I had turned this off. Spam, of course. So is El Paso Electric Company eligible under the terms of that RFP to bid in the unallocated portion of the Santa Teresa BESS, 100 megawatts?
No, ma'am. The Santa Teresa project is a third-party project. It's not owned by EPE, so EPE would not be able to bid in a portion of a third-party project. Plus, those 100 megawatts are not separate or additional. They are a part of the facility as a whole, 150 solar, 150 battery.
Okay. So if they're not separate, and the commission does deny the request here, does that mean that the company has a stranded asset on its hand in regulatory speak?
Sorry, can you rephrase that?
If you are not able to separate or somehow resell that 100 megawatt chunk of capacity out of the Santa Teresa BESS, which I think Mr. Villalobos maybe sort of suggested was a possibility.
I am
If you can't do that, if you cannot do that, is it a stranded asset that you just cannot do anything with other than wait till New Mexico approves it?
Well, no, the asset would still be operational and useful. I suppose it depends on what you mean by stranded asset regulatory speak.
For regulatory purposes, if New Mexico says, think about maybe Palo Verde 3 or something. If New Mexico says no, but it's tied up with the rest of the other plant, as you just said, and can't be separated, would that mean it just sits there idle?
I see your confusion. So when I say that it can't be separated, it's because the project was bid in entirely. It's 150 megawatts of solar, 150 megawatts of battery, but they are two separate batteries, a 100 megawatt battery and a 50 megawatt battery at the same site. So technically, yes, it can be used for other purposes, I guess by your definition, if it were to be stranded.
So it could be, so I thought your first reason that you said it couldn't be bid into the RFP was because it was a third party asset, but I'm saying like it's sort of like a sublease or sublease of by the company. Could the company, as Mr. Mr. Novella possibly suggested, he was saying that it was a generic statement, that is it possible for the company to make that capacity available to either the Texas jurisdiction or to an absolute third party like a data center, kind of in the same way that it treats the the New Mexico allocation of Palo Verde 3 as a
This,
saleable asset, just saleable asset to somebody else because it's not claimed by one or the other jurisdiction?
I object to the form of the question. There's a lot of commentary and testimony and confusing and vague what the question is.
Objection sustained, Ms. Stevens. Please
Okay.
ask a question, proceed to the next question. It got quite
Okay.
long there, especially when you started to get into Palo Verde, which isn't even part of this case.
Yeah.
And we don't know if we even need that
Okay.
analogy. So please try again.
Is it now I've lost you down the bottom there. Mr. Villalobos, is it possible physically for EPE to make arrangements so that somebody other than the New Mexico EPE retail jurisdiction would be able to use that 100 megawatt piece of the Santa Teresa BESS?
That isn't something that we've considered. I guess if you can give me a minute to think about it. I'm trying to dissect your question. Is it possible physically? Like
I
from
said
an
like engineering wise.
I mean,
Sorry, please repeat it.
Ms.
I don't
Stevens,
know
please
what Ms.
repeat your
Stevens-
clarification of physically.
The clarification for physically was as in engineering wise.
I can go back and get that answer for you, Ms. Stevens. My understanding is that it is metered separately, so I think as far as the possibility exists, I think it could. Again, this is me just speaking not as an engineer, just from what my understanding is. But if it's very important, I can definitely track that down for you.
And this is probably even less in your ballpark, but contractually or legally, would it be possible for EP to do that?
As you said, even less in my ballpark.
Okay, that's what I thought would be your answer. Um, uh, Now, is the Santa Teresa BESS would you turn to CLC Exhibit 33?
Just give me a moment. Okay.
Okay, and I'd like you to go to question 119 and 120, both of which were sponsored by yourself. I don't think you necessarily need to read the thing. This is just to let you know that why I'm asking you is the Santa Teresa BESS eligible to be charged from the grid as opposed to from the Santa Teresa solar project?
The Santa Teresa project is capable of both grid charging and charging from the solar facility.
And in these responses, I think it was 120C, it says that the Carney BESS charged from the grid only on one day. Is that correct still, since the time this discovery response was submitted?
My understanding is that is still correct from the day this was submitted.
And now that you've just told me that actually oh, it's the Carney best, not the Santa Teresa. Santa Teresa and Carney are both capable of being charged from the grid, is that right?
Yes, they are.
And was the commission informed of that at the time that each project was approved under the Renewable Energy Act?
I'm sorry, can you rephrase that?
Was the commission when the company was asking for approvals of both Carney and case 22000093 and Santa Teresa in last year's REA case, was the commission told that the BESS could be charged from the grid? Or was it?
I'm sorry, I can't speak to the Carney case 22, whatever the
Whatever.
number was there. Yeah, sorry. I wasn't a part of that case. For the 25 case, last year's RPS case, I do not recall if it was explicitly said, but if it is anywhere, it would be in the contracts for that facility, and those, I believe, were a part of that previous case.
And let's see. So I think I was told that by Mr. Novella that you know more about the precedent agreement concerning the potential large load customer in Doña Ana County than he does. So could you just quickly tell me what step? First of all, is that true? Are you familiar with that precedent agreement?
No, ma'am, I'm sorry.
Are you familiar in any way with what's going on in terms of attempting to serve a large load customer in the state of New Mexico?
I am aware of what's going on the periphery as it would apply to our department when it comes to planning. If you're inferring that, like, am I a part of the conversations? That's a business development team. That's not us on the planning side.
And would you please turn to your exhibit 4 of your direct testimony, EV4 of your direct. So here, I'm making bigger, not smaller. Is this the company's most recent loads and resources table for New Mexico?
I'm sorry, ma'am. I'm just,
Oh, you're still looking for it, pardon me.
yeah, the computer decided to freeze on me for a second, so it's going now. So you said go to my direct testimony and then where?
Yeah. Exhibit EV4 on page 50 of 52 on the little buttons on the side, PDF buttons.
Thank you. That is helpful. Okay, I'm there.
Okay. So this information is crucial to your analysis in this case, right? Loads
it is a part of the case, the analysis.
Yeah. And so I'll just ask you a few basic questions here. The very first column for 2026, where it lists at the top a whole bunch of new resources. Does this assume, the listing those resources, does that assume that each of those resources was predicted to be fully in operation by the peak day of the summer of 2026?
So yes and no, depending on how you're looking at it. So if it's in the column there for 2026, that means this expected COD is within the year of 2026. But if it's not accounted for within the rows, that would have been because it was not online for the peak of that year. But If it's in the 2026 column, it's probably a pretty safe bet that it's accounted for there for
Yeah.
peak 2026.
Because you're predicting from April 28th to the following to the summer, right? Okay. And now this case is about 2027. So if we look at the 2027 column, I see a new large load customer value in 2027 of 68 new megawatts of peak load. And then when you get down to the bottom, the net resource position is a 68 megawatt deficit. Is that right?
Yes, that is correct.
So is it reasonable to conclude that EPEs need, at least in 2027, for additional capacity of any sort, whether it's renewable or otherwise, is driven literally by the new large load customer?
No, I wouldn't agree with that characterization, actually. When we're putting together this table, we're looking at a 20-year horizon. So when we're looking at it from a resource planning perspective, we're not planning for 1 year up, if that makes sense. We're taking into account the load growth trends and resource retirements and acquisitions and all of that. So it's the best available resource eligible for New Mexico now at this time. And because we're selecting everything on a portfolio basis, on the least cost portfolio, I wouldn't focus on it being driven like 1 year, one customer. The decision is driven off of the 20-year outlook.
And this least cost portfolio concept, explain to me how that fits into the loads and resources table.
So when we run an RFP and resources are selected, the result of the RFP is that we get the least cost portfolio of resources, what would be the most affordable, efficient way to meet growing system demand. The Santa Teresa project was a project that was competitively selected through a solicitation, through an RFP. So it was a part of the least cost portfolio for our system that would be available for customers.
And at the time it was selected in a Texas RFP, wasn't it?
No, actually, it was selected from the 2023 New Mexico RPS RFP. If you recall, in 2023, we actually had two RFPs running, a 2023 Texas and a 2023 New Mexico RPS RFP. I think the resource selection here was for the 2026 New Mexico RFP, and I apologize, I'm going off of memory here. But I think it was also selected in the Texas RFP. I think it was selected in both.
Okay. Would you please turn to CLC exhibit number 1, which would actually corrected, now I've got the wrong correction, as corrected by the hearing examiner. I don't know whether you've got it now. Did you download what was uploaded this early this afternoon?
No, ma'am. I just walked into the room here, so I have not
okay.
anything.
Um,
I have here CLC Exhibit 1 is application Anastasia Stevens.
Yeah. Well, why don't it's a little awkward. The correction was just to get page numbers on it, because if you look at that, it's kind of like lacking page numbers. But
I'm
we
going
can
to
work
interrupt for
with
a
that.
second. Mr. Villalobos,
Yes, sir.
this morning with Mr. Novella, he notified us that your case regulatory team provided him with a corrected exhibit number 1 that had been emailed by the city of Las Cruces over the weekend to all parties. Did that same regulatory team provide you with that document? You may have this document if so.
If it's in the same folder that he's talking about, then yes.
Replace.
They're coming in to help save me and tell me where it is.
Excellent, thank you.
In the meantime, Mr. Villalobos, maybe without even seeing the document, I can refresh your recollection insofar as in last year's case, Mr. Wayne Oliver.
I'm pausing your time, Miss Stevens. This is fine. Let's
What?
let them get I'm pausing your time,
Okay.
and we're gonna let Mr. Villalobos get situated with
And
Miss
Miss
Pleasant there.
Pleasant
And
to help him.
yeah, and so I'm putting a slight pause on your time.
Thank you.
We'll just do one thing at a time, and hopefully that takes a little bit of the pressure off of everybody. Okay, Mr. Villalobos, do you have that document with you now?
Okay.
Oh, sorry. Yes, I have it now. Thank you.
Okay.
Excellent,
If
wonderful.
we go to Oliver. We go to the direct test, well, the report that Mr. Oliver, the outside, what do they call him? The independent evaluator prepared about concerning the RFP process.
What
and
page?
I'm trying to find it here because he does it sort of twice. You could look at page 44 in his exhibit, his final report, or going back to the PDF page, like page 849, thereabouts.
You said 849?
849.
Okay, 849. I'm there. I'm at that page.
Okay. And I think this probably, if you start with paragraph 3 or even eyeball paragraph 2, this is what you were referring to, that there was a New Mexico RFP outstanding at the same time as the Texas one. Is it correct that EP was looking for 150 megawatt hours of renewable energy at that point for RPS purposes, which would be approximately 50 megawatts of solar, and the company going on and on. It's just longer. This is more detailed than the version I was looking for.
Mr. Hearing Examiner, I'm objecting
Paragraph
to this
15.
question.
Ms. Stevens, there's an objection being lodged. Proceed, Ms. Olson.
It sounds to me like Ms. Stevens is either just reading or summarizing prior testimony, and is not asking Mr. Villalobos
Okay.
a question, nor has she established that Mr. Villalobos has personal knowledge to be able to testify to what was in Mr. Oliver's direct testimony in a prior case.
I'm going to sustain the objection along the lines of Ms. Stevens, can you locate where you want to go, direct the witness to that location, and then
Okay.
proceed with questioning.
And
We're
I did
mixing
have
our,
notes. Sorry. I did have notes, but they were in like preparation for Mr. Novella. So let me find it. Let me find it. I think
and
there is a place in his actual testimony and not in the report that's a little more concise. Give it to me. That report is long. I wonder if this is taking so long. Pardon me. He's got a lot of resume. Okay, now let's go to his testimony, Mr. Villalobos. And
Ms. Stevens, which testimony are we in? What
Mr.
exhibit are
Wayne
we in?
J. Oliver's testimony in case direct testimony in case 25-00038. And he's describing the RFP process and the fact that there were two parallel
And is this in a
RFPs.
particular exhibit, Miss
It
Stevens?
was attached to the application, so it doesn't have an exhibit. In my
Exactly.
exhibits, it's the replacement exhibit number 1.
Okay, so we're still there. Okay, excellent.
So
Thank you.
I'm sorry.
So we're in
Okay, I
CLC
thought we all
exhibit
knew
number
that
1,
much.
corrected number 1.
Yeah.
Okay. And I'll let you
And
proceed from there. Thank you.
okay, great, thank you. So I would, I guess, probably start you at page 765 of 876 of the PDF.
Page 6.
765, that would be, it looks like page 15 of his testimony.
Correct, yeah.
Is there a question?
Yeah, so you testified that you thought that there was a separate RFP for New Mexico that resulted in the STP choice. And I just wanted to have you clarify or revise or clarify your position to acknowledge that what happened was this was in 2023, a while ago. There was an RFP for New Mexico, as he says, undertaken somewhat in parallel with the 2023 all source RFP for Texas.
Mr. Hearing Examiner, I object to this. Ms. Stevens is testifying.
I sustain the objection. You can refer the witness to the exhibit, but then please ask a question with respect
Okay.
to it, Ms. Stevens.
Are you with me on page 15, paragraph 9, Mr. Villalobos?
I see page 15, paragraph 9. Yes,
Okay.
ma'am.
Oops, oh darn, I just killed it. And does it help refresh your recollection that there were two RFPs going simultaneously? One for New Mexico, one for Texas.
I'm sorry, what's your question?
Does this, do you now believe, after looking at this, that there were two RFPs in 2023 going on simultaneously or essentially simultaneously in New Mexico and Texas.
Mr. Hearing Examiner, that was Mr. Villalobos's testimony.
He was uncertain.
All right, was there an objection just lodged by the company? Or was
Yes,
that commentary?
I object to this question as misrepresenting Mr. Villalobos's testimony.
Sorry, you cut out for me. Can you repeat that?
I object to this question as mischaracterization of Mr. Villalobos's testimony.
I sustain the objection. Let's just
Let's
ask a
just
question,
move
Ms.
on
Stevens.
because nobody here. Let's just move on because my time is short. And let me see what I have here. So let's go back to, let's close this exhibit and go back to Exhibit 26. Did you say that you were familiar with this RFP, Mr. Villalobos?
Okay,
The
so get out of this exhibit and go to exhibit
26, CLC number 26.
Okay. This looks like it's the 2026 New Mexico all source RFP.
And are you familiar with it?
Yes.
Okay. I'm going to move to admit exhibit number 26 and so we can move on, I hope.
I object to admission of this document. It's not covered by any of the witnesses' testimonies, and it's not relevant to the proposal that's at issue in this proceeding.
Would you like to respond, Ms. Stevens?
Yes, it's relevant in that Mr. Villalobos and especially Mr. Villalobos and the other witnesses as well in this case say that this request for the 100 megawatts of Santa Teresa BESS at $15.5+ million a year is absolutely necessitated by current needs that can't be met in any other way. And the point here is that the company is in the process of seeking capacity through an RFP in accordance with the commission's IRP processes and not taking shortcuts and just saying, oh, we have this thing in our back pocket, so we think it's great and you should have it. That's the reason for this. It's an option. It's an option that the company failed to consider before it proposed. In my opinion, it's an option that the company failed to consider before it came and filed its request saying that Santa Teresa 100 megawatts is the only thing that can ever save us.
May I briefly respond?
Yes, Ms. Wilson.
Hearing examiner, the city has not offered testimony or witnesses in this case, and I don't believe that Ms. Stevens has established through Mr. Villalobos that this pending RFP, which we've established is ongoing, has the ability to procure resources that will come online in 2027, and therefore I don't think it's relevant or informative to the tribunal on what resources may or may not be available to select from for 2027.
Okay,
May I respond?
thank you. I'm going to proceed for a second. I'm familiar with testimony with respect to resources and exhibits that are attached to Mr. Villalobos's rebuttal testimony that speaks to resources that can be acquired. My question is, Ms. Stevens, is this exhibit purely the RFP document, nothing else?
There's a little bit of there's a little bit, a few pages at the start of the company's redlining of their draft that they submitted pursuant to the RFP rule. The new RFP rule makes the company submit a draft to the commission, and so
Can you point me
there's
to that page,
colorful
please?
pages, otherwise it's the RFP.
Can you
Beginning
point me
on
to those
page 8,
pages,
it's the
please?
RFP.
Beginning on page 8 is the RFP.
Or actually, beginning on page 7, or it's 8. The cover page, the fancy cover page is 8. The pages before that are what the company filed with the PRC, which I thought was a better way of presenting it than just going onto EP's website and downloading it.
Okay.
Mr. Hearing Examiner, if it's helpful, this is a document on file with the commission. If the hearing examiners want to take administrative notice of the presence of this filing, I wouldn't object to that. I'm concerned of it being offered into as evidence in this proceeding because we don't have we haven't elicited testimony that would show this is helpful to evaluate availability of resources.
So,
May I say one clarification here?
no, please, everybody, give me a second here. And I'm gonna just 1 second. Can you restate what you would be okay with, Miss Olson?
Yes, this is a document that's on file with the commission. And so if the hearing examiners wanted to take administrative notice of the presence of this filing and the fact that there is a pending RFP, EPE wouldn't object to that. My objection is to the misuse of this document as concrete evidence regarding resources that may or may not be available because this is an ongoing RFP.
Okay. I believe there's extensive testimony as to the necessity for the Santa Teresa 100 megawatt BESS, and that necessity is provided in testimony in relation to the other options that are available. I therefore think this document is relevant. The witness that's on the stand has spoken to his familiarity with this document, and I'm going to take administrative notice of this document into the record. CLC exhibit number 26 is admitted to the record through administrative notice. You may proceed to ask questions with respect to this document, Ms. Stevens.
Thank you. And my question, I have just one question on this document. Well, 2 questions on this document. First of all, if you turn to PDF page 17, which is page 10 of the RFP itself. Mr. Villalobos, you see that?
Yes, I'm there.
Okay. And does that indicate that EPE, what is in this pending RFP, actually seeking capacity for New Mexico in 2027?
Are you asking if EPE is looking for capacity in 2027?
Right. Yeah,
Yes,
based
on the table it
Right.
shows 100
Okay.
megawatts for 2027.
So you are looking short term as well as, you're looking for something available near term and farther out.
Yes, as early as 2027.
Thank you. I think that's really the point I wanted to make. And I thank you, Mr. Villalobos. And let's move on because I haven't much time. So, this goes to my attempt to clarify or through voir dire your rebuttal versus your direct testimony concerning that I'm going to close concerning the round trip losses And the little table that shows your change table that shows the round trip losses, which is table EV1 in the direct and table EV1R in the rebuttal testimony. And if you could look at both of those or try to look at both of those, I just want to ask, honestly, do you think that they represent the same thing or that there's something has been changed? Is it just a different presentation of the same information? Or have you, in your analysis of round trip losses, actually changed your reasoning?
Okay, so there was a couple of questions
In there.
in there. Let me
Okay.
try
Yeah.
to break that down. But
Okay.
first you wanted me to look at both exhibits.
Both exhibits where those tables are and the testimony that sort of surrounds them.
I'm gonna step in just and Ms. Stevens, I know you're feeling time pressure, but please, we're gonna save more time if you can direct us to the page numbers first, please. It's
Okay.
going to help in the long run.
Okay.
So in the rebuttal testimony, what page are we looking at? I believe it's page 6.
In the rebuttal, okay. In the direct, it's page 28.
Okay.
And in the rebuttal, where I've got, no, sorry, I've got 2 directs open and not 1 rebuttal. And in the rebuttal, as you say, it is on page 6. And my question to you kind of basically is that the explanation of the changes, as I understand them, seems to be saying that you place the curtailments in a different place so that they would be more obvious. Is that right? Or more separated and in the corrected version compared to the original version?
Okay, so I addressed this in my rebuttal testimony in a couple of questions. So there were 2 items that we can comment on. I don't know if you'd rather we read the Q&As and I can help explain where I may have lost you. But are you asking specifically for which portion of the table, round trip efficiency losses or?
I guess what I'm asking for is what you believed you were changing, if you believed you were changing anything, or whether it was just a change in the visual or representation of things. Does that make sense?
I think so. I think I'm following you. So in the rebuttal testimony, we do say that as we were going through discovery, we did find an error in the tables. As we're transitioning and using the Plexos modeling and we deal with new output reports and formatting and all that, the error that we had was the number that got spit out by the model was already net of round trip efficiency losses. And mechanically speaking, we were so used to doing that subtraction in the table here. So it was done in the model and then it was mistakenly done again in the table, which means we double counted the round trip efficiency losses. So that, as we were going through and it was pointed out by staff testimony and I believe in your RFIs, we corrected that.
And the differences though, the only difference is I'm looking at the 2027 column. Am I correct in saying that the differences show up in the Carne Solar and Santa Teresa solar lines? And not in the other lines? Not in the community solar or the existing resources?
Yes, that's correct. The double counting was on Carne and Santa Teresa.
But the change, the increase from the EV1 to the rebuttal is considerably larger than 53,904. This is where I guess I'm having difficulty in understanding how much the level of the change if it's essentially the same calculation. You know what I mean?
Okay, so let me think of a way to rephrase that without just repeating myself. I don't know how else to rephrase it. I apologize. So the issue is that the round trip efficiency losses, the 15%, roughly 15% efficiency loss that you get from using the batteries was mistakenly added again. So whereas in the original numbers, that's what that difference would have been. It was in the original numbers in the table, and then we added it again mechanically in the table by mistake, because in the output from the report, it was already netted out. So that's why that figure appears higher after the fact or lower upfront.
And I'm just eyeballing it. The difference is like between the Carne and Santa Teresa, it's like 125,000 megawatt hours. I guess I'm wondering what was doubled. They could be that large in scale, given that you're ultimately showing the round trip efficiency losses for everything put together is 53,904.
Okay,
That's why I'm
so
wondering whether there's actually other changes incorporated.
we go through a couple of mathematical examples in the rebuttal testimony to kind of help you out, but I don't know if what you're also looking at is what's labeled as planned solar energy curtailments. That one was one that was, I guess, just the way I'm presenting it was also removed, but as we were going through not removed, just netted out in the top number. As we were going through the discovery and we noticed that you all were using the previous year's table to compare to this year's table, we just figured we'd added back in the column, the row. The calculation was still in there in the original EV1. The only error in EV1 was the double counting of the round trip efficiency. But as we were going through the discovery and we fixed that issue and we noticed that people were comparing the previous year's table to this year's table, we just separated that line item again so that it would make it easier for you all to compare last year's to this year's corrected table.
And I'm just again wondering how the so-called double collecting makes a difference of 76, almost 76,000.
If I may, I'm going to step in here for a second and see if I can clarify the question. Mr. Villalobos, on the corrected table EV1, I see a margin deficiency for 2027 of 200,612. On the RPS position margin deficiency for 2027 in table EV1, I see 92,758. The difference between those two numbers is approximately 108,000. If the round trip efficiency losses represented in red in the fourth row from the bottom is 53,904, and that's the number that has been duplicated in the original table EV1, I would expect that we would see a difference in the RPS positions between the corrected table and the original table in the amount of 53,904. But I'm seeing a difference of approximately 108,000. So if the only change was that the round trip efficiency loss was counted twice, in other words, 53,904 was counted twice, what accounts for there being a margin deficiency of 108,000, which is not exactly double 53,904, but close? Can you explain that, please?
Okay, so thank you. When you do the calculation in the table outside, you're doing a 15% multiplication of the value that you see for Carne Solar and Santa Teresa Solar. So 15% of a higher number versus 15% of a lower number gives you that discrepancy. So it's not just that, it's also multiplying a percentage of a different number.
So the 200,612 that we see in corrected table EV1 would be 53,904 of round trip efficiency losses plus 15% times the Carne Solar number of 398,000 approximately, and 15% of the Santa Teresa Solar, 476,000. Did I understand that correctly?
It should be, if we're saying the same thing, I think we are. I don't have a calculator in front of me, but
I'll do a little bit of math in the background, and Ms. Stevens, I'll hand it back to you.
I was trying to do the same. And to put that like in one sentence, let's look at the Carne Solar and the revised version. So if we took 15% of 398,000, I get 59,751, which is a bigger number than the total round trip efficiency losses. And I think that's where I'm confounded. That and I don't know whether it's because, like Mr. Gecko was alluding to, should something be doubled and then counted again, or what? It's just intuitively, I just am having trouble. And I thought that and on top of that, I thought that your verbal explanation of the difference was that the original version, or part of your verbal difference was the original version had the curtailments embedded into the numbers, and that your revised version, thankfully, consistent with previous filings, has the solar curtailments separately. But again, the numbers, the scale of the numbers, the level of the numbers, magnitude of the numbers is leaving me kind of clueless. And I'm sorry, I probably shouldn't be spending all my time here on this, but I just don't understand it. I don't know whether there's a better way. Maybe I should leave it to Mr. Getko to ask in his examination.
I'd rather clarify right now, because I think understanding
I
numbers
think
is
you're in the
important.
same.
Let me step in, Ms. Stevens. Thank you. Mr. Villalobos, could you just tell us what numbers go into the 200,612 in the corrected table EV1?
what numbers go into the
that add
200,000.
up to that? Is it all of the numbers above it, for example? Can you just walk us through that first column there, please?
So it would be the difference between your RPS energy requirement, the 932, 140, and your total projected RPS REX, which is the secondary blue line of 1,132,752.
Okay.
If you take the projected REX of 1.1 million minus the RPS requirement of 932,000, you get 200,612. As I was mentioning earlier to Ms. Stevens, we were taking the numbers that come from the output report of the Plexos modeling, and there was an error there with the double counting, but also how these were originally counted was based off of the expected energy out of the contract versus what the model was actually kicking out. So that's part of the discrepancy there, is we're looking at the expected energy from the contract versus what was originally from the model that was netted out. So there is some slight differences in what the model kicked out versus what contractually was there.
Okay, so that is something that you didn't describe in either testimony, right? This idea that the results, it's not a matter of simple arithmetic that you take X, a projection of output, take off the 15%, let Plexus figure out the curtailments, and away you go. There's something more complicated in there in the Plexus process. Would that be fair to say?
I'm not sure I'm following your.
Well, I think what you just said was that there's a difference in between the two exhibits, two tables, there's a difference in whether the contractual production is sort of the starting point, or a projection somewhat developed within your Plexus model is that right?
There is a difference between the energy that is output from the model and Plexos. There is a slight variation to what the expected output of the facility is contractually, or when they do expected output in the contracts.
So could we just look at one pair of numbers, maybe as an example? And I would say, let's, so that we don't get roiled up in Santa Teresa, let's look at the Carne Solar line.
Okay.
And in the table, the first table, EV1, which has the lower value, what adjustments within that lower value were reversed to get the higher value in the corrected one?
What numbers were reversed?
Or what numbers were altered? What numbers were altered so that you went from 342,797 to 398,000?
I'm trying to think if we put in that example in the rebuttal testimony. Maybe give me a second to look for.
Well, Well, pages 29 and 30 of the rebuttal do some round trip losses calculations for Santa Teresa. So if you think it would be better to move to the Santa Teresa row, please do just let us know.
Yes, I think that would be best, but I'm trying to find the page. Could you point me to which queue that is?
It's a long one, Q46. Oh, that's it. I'm sorry. I mean, that's the direct. Hold on, I've lost the rebuttal now.
I'm sorry, that's the what?
That was the direct testimony, not the rebuttal. So, oh, why did it? Oh, okay. In the I'm sorry. In the rebuttal, there's a question 9 beginning on 4 that kind of, and then question 10 beginning on 5 about Carne. But it doesn't itemize all the numbers, if you know what I mean.
Okay, so if we're going through question 9, where it's asking for the mathematical example. If you see for Santa Teresa, the 400,810 number that was in the table EV1, and if you divide that by the same value in the tables, the corrected table for Santa Teresa Solar, which was 476,542, that difference is about 84.1%. So that's roughly the 85% that you get from the round trip efficiency losses.
Okay, so that's how you grossed it up going. Okay.
And then you do the same for the for the Carne facility, and I believe that's the following question 10.
And then your rebuttal testimony on the 2 reasons you give on page 5 of your rebuttal. One is the double counting, and I think that's what you're saying here. And the overstatement of losses, that is not something you've attempted to quantify, is it?
Is the overstatement of losses something we've attempted to quantify?
Well, you say it's this methodology is incorrect. Double counting, I think we've addressed that. And then overstatement of losses. This approach incorrectly assumes 100% of the solar generation is routed through the battery. In reality, the battery is restricted by both its physical charging, discharging capabilities, and its contractual annual limitations. So I'm asking whether in the rebuttal version, you made some sort of a correction to different correction to different or additional correction, I should say, to capture the number of annual cycles that you had not done in the direct testimony.
For that second part, the overstatement of losses,
Yeah.
no. The error there would make the losses deduction artificially high, right? So the correction there would just make your position better.
And then I guess I would go take you back to, at the risk of making us all insane, take you back to
Sorry, at the risk of what?
making us
Sorry.
all insane, take you back to question 48 on your direct, which was really my notes. I have this question. I didn't realize we'd get this bogged down. Is that question 46 in your direct seems to be explicitly calculating a round trip efficiency loss based on not all the power going through the battery, but 340 cycles at whatever it takes to fill the battery. So that definition or the verbal description in the rebuttal about overstatement of losses seems to maybe have been already addressed in your direct. Is that possible? Does that make sense?
You said question 48 and then you said question
46 beginning on page 29 of the direct.
Okay, you can give me a minute to refresh my memory. Okay, so I read the Q&A. It's referring back to table EV1. Okay, so what is your question, Ms. Stevens? I read the question.
The question is, did you, in fact, based on this testimony, question 46 in your direct, did you already address what you claim is one of the problems in your rebuttal about overstatement of losses because you did use 340 cycles? Or did you make a further adjustment for even fewer cycles, I guess I could say.
There wasn't a further adjustment. I think the miscommunication there is that the double counting error was just a straight multiplication, which led to an overstatement of the losses.
Okay. And now that we're sitting on it, I'll ask one more question, and then we'll move on to something. Maybe we should ask for a break to clear our heads. And that is, I'm looking again at the direct, and on page 30, lines 7 through 10, and it says that assuming EPE cycles the battery, this is the whole 150 megawatt battery, the total of 340 cycles per year, EPE can expect round trip efficiency losses of approximately 35,700 megawatt hours.
I'm sorry, what was the amount of the megawatt hours?
35,700.
Thank you.
And this one's I hope a softball for both of us. So if the commission denied the Santa Teresa project and you were back to the 50 megawatts that were approved in the last case, the Santa Teresa total efficiency losses estimate would be 1/3 of the 35,700. Would it be 150 at 50 instead of 150? Or is it not a 1-to-1 relationship?
The round trip efficiency loss would be jurisdictionally for New Mexico, yes, it would be calculated off of the 50 megawatt battery.
So it would be 1/3 of the amount of losses stated in your testimony here for 150 megawatts of battery. Is that right? 50 versus 150?
Yeah, I'm with you, but I'm trying to understand exactly your question. I want to make sure I'm answering you correctly. I think if we're saying the same thing, I think we're on the same page. It's just the phrasing is kind of throwing me off a little.
So
I could put it in a
I'm going
slightly
back
different
to-
way.
Go
I'm
ahead.
sorry, I didn't hear that, Ms. Stevens.
I could try to put it in a slightly different way. I'm just doing the dumbest, simplest arithmetic. Mr. Villa was truly, I mean, I still use the calculator, old one, but I'm doing that. So if you go back to 50 megawatts, instead of this 35,700 number, you would have 2/3 of that go away, right? Because you'd be down to 50 megawatt. That's the question I'm asking, really. And that would be a reduction in losses of just pure arithmetic calculator of 23,800, which would be therefore an addition to the available RECs or available renewable energy. Does that make sense?
Mr. Hearing Examiner, I object.
Ms.
I think
Olson, what's
that's-
your objection?
I think this question is vague because I think we're confusing round trip efficiency losses for the facility and round trip efficiency losses that are assigned to New Mexico. And so I've lost track of Ms. Stevens' long question.
May I respond?
Yes, you may respond.
Yeah.
But
I'm
make
just
it brief because I think I already know where I stand on this,
Yeah.
please.
I think I'm just trying to figure out if we know that 50 megawatts is already assigned to New Mexico, and the question is if you what is the delta if the company's projections in this case do assume that the 150 is being assigned, and I'm going back to if the 150 isn't assigned and just using a 2/3 ratio. That's all I'm asking him. Is that simple
Yeah,
enough?
I'm going to deny the objection because I think it is my understanding of it. It's just aiming for an understanding of exactly what you described, Ms. Olson. And I'm going to step in here for a second and say to Mr. Villalobos, my understanding of the question that's being asked is we have a number that's 35,700 megawatt hours. That's on page 30, line 8 of your direct testimony. Those are round trip efficiency losses. is it correct that those are expected based upon an assignment of 150 megawatts of the Santa Teresa BESS?
In the example here in the question, yes, that's going off of the 150 megawatt hour battery.
Okay, if the 150 megawatt battery were not approved and instead you moved forward into 2027 with a 50 megawatt Santa Teresa battery, would it be correct to change 35,700 to a number that equals 35,700 times 0.333, repeating?
Yes, it makes sense to me that way. What I'm trying to think about in my head is how the remaining 100 megawatts of the battery would affect the overall system round trip efficiency losses. If some of the power there was routed to that battery anyway, that's why I'm trying to, yes, in theory, it would be 0.333%, but then in actual operation, if some energy does get diverted like that, it's kind of a nuanced thing, but on 50,000 foot view, yes.
Okay.
Thank you. I'm satisfied. I think, um, I don't know that hearing examiner is, but I think I am.
I'm sorry, I don't know if,
The hearing examiner is, but that satisfies my line of questioning. So I guess,
The-
should we go on?
And now I'm the one that will risk, I'd like to ask a couple questions, Mr. Villalobos, just to get a little bit clearer and help me understand what I don't understand. And let me get to the right spot in your direct testimony again. So in your direct testimony on page 28, you provide table EV1. And on page 6 of your rebuttal testimony, you provide corrected table EV1. In both those tables, you have the same RPS energy requirement of 932,140, correct?
Yes.
And in both tables, you have a line item that is round trip efficiency losses in the red of 53,904. Is that correct?
Yes.
In the corrected table EV1, the 53,904 that we see, is that calculated from the Carne solar line and the Santa Teresa solar line in some kind of multiplication of about 15% to get you to 53,904?
Is that your, that's the question?
Yes.
I believe that it is. I'm just trying to remember if that number was inclusive of other batteries on the system and not just the two that were listed here.
Okay, well, if there were another battery on the system that isn't included here, that would mean that the 53,904 becomes a bigger red number, correct? Because you would have additional round trip efficiency losses from an additional battery that has not been taken into account yet, correct?
Yes, that would be correct if there wasn't another battery that was not being taken into account there.
Okay, so did I understand correctly that you calculate round trip efficiency losses as approximately 15% for both the Carne solar and the Santa Teresa solar? Approximately 15%.
Yes.
Okay. Can you please do the math of what 15% times 398,343 is?
398, 343 times the 15%. That's the 59,751.
Okay. How do I understand? And okay, so 59,000, can you say that number again, please?
59,751.
Okay, here's where I get lost. Is 59,751 there the estimated round trip efficiency loss from the Carne solar resource? Yes or no? Sorry.
Yeah, I think I'm starting to get a little jumbled up now too on the question.
So here's where here's where I'm confused. If we look at the column for 2027 in corrected table EV1, and we go down to the row that's labeled Carne solar, and we go over and we see that number 398,343. That's the projected energy production in megawatt hours, is my understanding.
Yes.
Because we don't want to double count, we haven't taken round trip efficiency losses off of that number. Correct?
That's correct.
Okay, so if that number is 59,751 from that one single resource, how do I understand a round trip efficiency loss row that tells me the total round trip efficiency losses are 53,904, which is approximately 6,000 less than what we just calculated as the round trip efficiency loss just from Carne solar?
I apologize, Mr. Hearing Examiner. I'm gonna have to go back and think about that calculation here. I know there's something that I'm misremembering here.
Okay, okay, that's super helpful, and then we can reconvene in the morning on that item, and that'll allow you to review the numbers and the calculations. And I appreciate you asking my question to help me understand that maybe my confusion right now isn't crazy. And so I appreciate that. And I'm going to let Ms. Stevens continue with her other line of questioning. And then in the morning, when it comes to my turn, I may ask some more questions about these two exhibits.
Yes, absolutely.
Thank you.
And before we leave these documents, this is not something I terribly want, but I want to get it on the table in case we decide we need more, information. It's the curtailment side of this equation, Mr. Villanovas. Does on the rebuttal testimony, the 23,424 figure, is it like your correction to table EV1? Is that something that was reduction on EV1? Is that exact 23,424 comprised or buried somewhere in the energy numbers for RPS Energy Resources existing, Carne Solar, Santa Teresa Solar, New Mexico Community Solar, distributed generation, one or more of those components? It looks to me, I would just say, it looks like the numbers that have changed are only Santa Teresa and Carne, but we're now talking about really big changes there. So I'm not sure where you pulled out the curtailments from.
The planned solar energy curtailments values that you see there are the curtailments that we get from the modeling for the entire system. So those are, how can I phrase that?
And then are they then prorated or something for the New Mexico RPS calculation?
Yeah, yes, but I'm trying to figure out, I'm trying to think of how to phrase it so that we don't get jumbled up on the same.
I've been in a lot of these cases, and I know there's
Was
a lot
it-
of stuff that goes on in the model, but I just wondered
Ms. Stevens,
whether
let's let him finish that
at
answer.
some point it comes to a 1-to-1 ratio, 1-to-1.
So the planned solar energy curtailments that you see there are the curtailments that you see despite having all of the battery already operational, if that makes sense.
Yes.
So those are the curtailments above, not incrementally from having the battery 50 or 150. It's the curtailments
Maxed out.
yes.
Maxed out.
Yes.
Wait,
I'm sorry.
I'm gonna ask that we let the witness finish his answer and then ask the question, please. Please continue, Mr. Villalobos.
So those are the curtailments that we see on the system above the batteries that we're talking about. So again, the Santa Teresa battery, even though 50 megawatts of it was allocated to New Mexico, the 150 megawatt battery is still being modeled in the system. And those are the energy curtailments that you see above, even after you have the batteries.
May is he mine? Is the witness
Ye-
mine,
yes,
Mr.
Ms.
Hearing
Stevens.
examiner?
Yes.
Thank you, Mr. Ely. He's a nice man.
All yours, Ms. Stevens.
Okay, so let's go back with that segue. Let's go back to CLC Exhibit 33, please. It's the discovery responses. I think we had open, I think, earlier. And if you go to that 120, that response 120, it's followed by an exhibit that shows many, many, many 190 pages of hourly battery activity for Carne.
Oh, okay.
Okay. And you take your time, to read what it is, but it's referenced in 120, the response to 120.
Okay.
Okay.
I see the exhibit and I'm at CLC 120.
Mhm. So this is kind of this is obviously a representation of how the Carne battery was used, right? Not a hypothetical. And I'm just wondering why one does not see lots of big numbers in there. Well, where one sees days where no activity occurs or minimal activity occurs, fractions of a megawatt. And then when there are groupings of activities, they don't necessarily seem to add up to 4 times 65, which would be when I get percent to fully charge the battery. And again, I'm not quite sure how operational your knowledge is, but if you can give me some explanation of what you know about the real live use of what I think is El Paso Electric's first really large battery, well, like maybe
Ms.
Buena Vista, I
Stevens?
don't have that,
Ms.
but
Stevens, can you please state the question?
okay, the
Now that
question
we're in
is,
the,
can you please tell me why, looking at all these zeros and low numbers, how reality coincides with what you've just been telling us about projecting round trip efficiency losses and solar curtailments. How does this depiction of reality relate to the theoretical treatment that we've just been discussing about modeling solar curtailments and estimating round trip losses?
Well, I mean, first I would caveat anything that I would say is that my department, we're not involved in the operations of the actual battery and how that gets dispatched. That would be for our system operations team and our energy management team on how the reality of how these things get operated would change day to day, hour to hour, different conditions on the system.
We don't
I don't,
have a
I don't know
witness
if
here,
that
do we,
helps.
who's quite that in that.
I'm sorry. There were two talking.
None of EP. Would you say that Mr. Novella would be a better? I know Mr. Gonzalez isn't because he's a rates guy. Do we have
No,
anybody who would be able to answer these questions in this hearing?
from us three witnesses.
Yes, from you, no. Okay. I guess that's my answer. Okay, let's try something entirely different now. A second to find one entirely different. I'm afraid your answer is probably going to be no, based on what you just said about, or maybe not, about your role, but would you look at CLC Exhibit 12, please?
Okay.
And you see that this is EPE's most recent so-called status report in case 22000093. Did you have
Yes,
anything to do with preparation of this report? I guess I could start with.
I am not directly involved in putting together this report.
Did given that this table B on page 4 of this report kind of looks like what we've just been looking at, looks a lot like what we've just been looking at. Do you know whether somebody in your department would have been crunching these numbers? This is 2026 figures, not 2027, but just given the format, does that mean it would be somebody in your department or not necessarily?
Not necessarily, but looking at it here, I would venture to say maybe.
Not you, obviously not you personally. Is that a fair conclusion? Okay. Mr. Hearing Examiner, Madam Hearing Examiner, the city would like to take administrative notice of CLC Exhibit 12, which was filed by the company in case number 22-00093 UT. And primarily the reason for this is that this is probably the most recent representation of what goes on in EPE's REA compliance world, because it's dated June 30th, 2026.
Are there any objections?
Mr. Hearing Examiner, I don't object to the hearing examiners taking administrative notice of the fact that this document is filed. I object to the hearing examiners looking at it. I guess the document speaks for itself, and I don't think that Ms. Stevens' interpretation or testimony regarding the document should be considered evidence.
Okay. Ms. Stevens' interpretation of the document is not accepted as evidence, but given the recent filing of this document into an official record at the commission, and the fact that it is tied explicitly to RECs and renewable energy, we will take administrative notice of CLC exhibit number 12.
Thank you.
Ms. Stevens, I'm going to give you just a quick time check, just so you know where you are. By my
Okay.
count, you have 38 minutes of cross left total.
Okay, thank you very much. I will quickly run through this and see what, I think that was, there is asked for administrative notice of this one.
I'm not hearing you or
No, I'm
understanding.
muttering to myself. I will.
Okay.
The city also moves to admit, or I guess admit, because it was under his name, that exhibits the CLC exhibit 31, the responses to 120 and 119, which cross-reference one another. And unfortunately, this is, I'll be on, this is the entire responses to city's first set, but what I'm aiming for to get into the record, I don't know, the best way to do that is just the answers to 119, 120, and that endless 190 pages of battery charging information.
Mr. Hearing Examiner, I object to the admission of CLC number 33. It contains a lot of information that has not been verified or testified to by any witness, and I think to the extent it's helpful, Mr. Villalobos's testimony to the information provides evidence that's needed.
So just to be clear, we're looking at CLC exhibit number 33. Number 31 was accidentally stated for a moment there. And what's been asked to be admitted most explicitly by the city are the responses to Discovery 1-20 and 1-19. Is that correct, Ms. Stevens?
Yes, including the exhibit, the exhibits to 120. I think that both exhibits are to 120.
I'm sorry,
Okay.
you think the what?
The exhibits are the exhibits that take up most of this document are offered as attachments to the response to CLC 120, there are attachments number 1 and attachment 2. And I would like that, of course, to be part of the exhibit, the admitted exhibit.
Okay, just 1 second, everybody. Let me catch up. Attachments 1 and 2 to CLC 1-20. There's attachment 1, reviewing. Okay. Similar to how we handled the matter earlier, I'm going to provide for entry of the exhibit, but limited, and I'll have to, similar to what Ms. Olson kindly did over the lunch hour, of pulling an element of an exhibit out of a larger exhibit for admittal. The same will need to be done here, so the objection is granted in part that Ms. Olson placed with respect to the totality of what is included in this document, and what will be admitted to the record are the questions and responses to CLC 1-19 and 1-20, as well as attachments 1 and 2 to CLC 1-20. And in the
Mr.
morning,
Henry, may I modify that slightly? The last few pages are the affirmations of Mr. Villalobos and Mr. Novella. Could those be included?
yes.
Thank you.
I'm going to do just a quick check-in here. We're getting close to the 5 o'clock hour. Do you still have a fair amount of questioning for Mr. Villalobos, Ms. Stevens?
Let's see. Given my time constraints, I think I would just like to ask Mr. Villalobos a little more about the exhibit at the end of his rebuttal testimony that I previously tried to strike it as a matter of a voir dire.
Okay,
Just
then what
just
I'm
a
going to
couple,
say
just
is,
probably just a couple
let's
of questions.
continue for 5 minutes, and if you're
Okay,
finished,
yeah,
then
it shouldn't take
so
even
be it.
that.
No, let me finish, Ms. Stevens. And if we're finished at that point, we'll be finished, and if not, we'll interrupt the questioning and we'll resume in the morning.
Okay.
So my question wasn't intended to place pressure on anyone. It was just simply trying to understand if, it was worth going till 5:15, etc. But I'm just going to make the decision thinking about it while I ask the question. We'll go for 5 more minutes, and then I'll wrap it up for the day. Okay, please proceed.
All right, now I'm going to have to try to open your testimony again because it's on the wrong screen. I'm sorry, I'm not good at moving things from the monitor to the desktop. I think I've got it now. Okay, no, I don't. So Mr. Villalobos, if you would look at your rebuttal testimony at question 21 on page 12. It's where you refer to discuss the analysis that's in your exhibits.
So you said page 12?
I think my notes say page 12, but I'm not. Oh, I'm sorry. I opened Mr. Novella's. That's why I'm not getting what I want. Gotcha. Okay. If I start fresh, this may even work better. Okay, it's on the right page now. So yeah, so let's go to 12 of your rebuttal. Question 21.
question 21, is that what you said?
21.
I'm there, I'm
And-
just reading
Yeah,
the,
okay. We're at this one. And this exhibit, which to describe as being a reflection of market prices, this involves, does this involve all of the bids to EPE's most recent RFP for resources? Or is it just ones that have battery storage?
this includes all of the bids that were past the like threshold review, made it to modeling, like went further into the process that we could actually evaluate them. Plus, they would be the ones that would be eligible for New Mexico's use.
Okay, good. So that 2025 RFP, the company is treating that as being for New Mexico. There was a, brouhaha. I mean, there were some issues back when it was filed about
Ms.
the
Stevens, you're testifying.
Okay,
Please
okay.
ask a question and be
This
clear as to
this
which
RFP
RFP you
is
are
still.
referring to. Please don't interrupt me.
I'm sorry.
I'm sorry.
I'm sorry.
Yeah, and we're about to finish, so please be clear to the RFP you're referring to, because
Okay.
we just looked at one. There's a different one referenced here. And please stay to the question, please.
This 2025, these exhibits show these exhibits show the bids that EPE received that passed at least the first threshold testing. Is that right?
Yes.
And they were received in what, the fall of 2025, late summer?
I'm sorry, what was your question?
Were they received by EP, were the bids received by EPE in late summer or fall of 2025?
Ooh, I don't recall. Fall, I think. I would have to go back and look at
Okay.
the RFP and look at the.
Has EPE made its final decisions about which of these resources to accept?
From the 2025 RFP?
Yes.
Yes, those selections were made.
And you earlier said that this would include ones that were eligible for use in New Mexico? Did I understand your statement a second ago that was included here?
I'm sorry, that was what?
That's what's included, that this reflects resources that EPE is considering or was considering for potential application or use in New Mexico.
So, no, what I meant by that was these were hybrid resources. So, for example, for RPS, a standalone battery on its own wouldn't qualify, so that wouldn't be here in this table that you're referring to.
Okay.
So these were the resources that were, I guess, apples to apples to what the sanitary facility would be. The 25 RFP was a Texas RFP. There was a blurb in there for if the company found a resource that could be used for New Mexico RPS purposes, but just given timeline constraints and what we were looking at, that's why the Santa Teresa facility is we see as the better option.
So none of these, just to close the loop here, none of these bids were accepted by EPE with the expectation that they would be used for New Mexico. Is that correct?
That is correct. None of these were selected for New Mexico.
And were any of them selected as a, quote unquote, system resource to be shared by New Mexico and Texas?
No, these were from the Texas RFP chosen for Texas.
Okay. That's my last question. Thank you so much.
No, thank you, Ms. Stevens. Always a pleasure.
Okay. The next step would be to ask Doñana County, but I'm going to save that question for the morning for when we begin. Unless, well, I can ask that one question. Mr. Herman, do you anticipate having questions for Mr. Villalobos?
No, I do not. Though I do have a housekeeping matter, but we can address that off the record.
Okay, then I will have some questions for Mr. Villalobos in the morning. So as far as still being on the record, that's going to conclude our questioning for today and the hearing for today. Mr. Villalobos is still under oath, and what we will do is resume at 9 a.m. again here on the same Zoom link. And I will, of course, turn it on a little bit in advance so we can all get situated. Before we go off the record, are there any questions for while we are on the record? Hearing none, we are going off the record. Okay, now that we're off the record, Mr. Herman, your housekeeping item.
Oh, this isn't really related to this, but and not that you're tech support for PRC 360, but I've noticed there have been some problems with it lately, and I was wondering if there was any updates on your end, whether or not it's been resolved.
I don't personally have an update today. I'm sorry.
That's all right. Thank you.
I don't think we've received any messages from Anna today telling us one way or the other. Poor woman, she's been busy.
Okay, well, with that, oh, I just received a message that actually
From Anna?
being told that the issues with E360 have been resolved. Sometimes we have staff that monitors these hearings. Messages will be sent out tomorrow with updates.
With, would you say updates? Oh,
Well, updates as to the functioning of E360,
okay,
not updates to the system.
we're not expecting to get bombarded with all the stuff that we didn't get for the last week and a half or so, huh?
We're going, no,
never-
we're gonna mail everything to your house, Miss Stevens.
Oh, well, that's okay.
Okay, on that note,
my recycling people, I don't know. Well, I have to do something some days to fill the bin.
Okay.
Because I won't throw away my old case files. I should, but I won't.
All right. On that note, everybody, I'm going to end the Zoom for today, and I'll see everybody in the morning. I hope you have a nice evening. Miss Lecoq, of course, will be with us. Do you have anything to add at this point, Miss Lecoq?
I don't. Thank you very much.
All right. Thank you, everybody. Have a good evening. Bye.
Thank you.
Thank you.